All right, Ms. Rivers, you ready? Let's get on the record. It's day 3 of State versus Tezera, 23 SC 191863, and we are waiting on our jurors to trickle in for their 9:30 arrival, and we're going to have our charge conference. Realize the state hasn't even rested yet, so the evidence is not complete, and we will have, of course, a refresher discussion about the charge because things could change between right now and when both sides have rested. But I think we can tackle 95% of what the charge will look like now so that that second charge conference can be short and sweet. Ms. Nix, anything we need to talk about before we dive into that? Okay, Mr. Hirsch?
Your Honor, yesterday, I think off the record, I had mentioned that due to, I'll say, I didn't have a video that came in, and that may be my issue. There's not a discovery issue whatsoever. The state has been extremely responsive and professional if I've needed anything.
This is the body cam video of Appleton.
Right, and I wasn't concerned about it. I sort of knew what was on it. There's no error whatsoever. If there is error, it might be on my part. But I certainly asked, I just asked the state if they would send me that video again, and very quickly last night they did. So I just want to perfect the record that I appreciate that and I have everything I need.
Great, thank you for fleshing that out. We did discuss that back in the hallway when we were working through juror questions for Officer Appleton, and given the state's representation that they would immediately get you what they contended was another copy of it, I assumed things were smoothed over, and I'm glad you put that on the record. So let's talk about the charge. I'm going to share my screen, and on that screen will be the draft charge. The way we do this is that I'm going to jump down to the first area where I've got a question. If I pass over an area where you had a question or a concern, say, let's go back to page 2, page 3. This is a document you already have. I sent it out, I think, 2 nights ago. And we'll work through concerns about what's in there that you think shouldn't be and what's missing if you think something is missing. And I'll repeat, I appreciate that both sides haven't rested yet, so there may need to be additional changes. But I think we've got a good sense of, in general, what it'll look like. So I go first to on page 3. You see on the screen, I don't think judicial notice ought to be in there. I don't know which side asked for it, but thus far I have not taken judicial notice of anything. I don't foresee that coming along. Ms. Nix, was that your request?
I think it was mine, Your Honor, but I don't see the state or defense having asked yet, so I have no problem taking it out.
Okay. Do you see a need for the judicial notice pattern charge, Mr. Hirsch?
No, sir.
Okay. It will likely come out. Again, we'll see what happens with the remaining witnesses, but don't expect it to be in the final charge. I've highlighted just the title, defendant's choice not to testify. I'm not committing anyone to any course of action. If Mr. Tezera chooses not to testify, that's the charge I'll give. Should he testify, I'll give a different charge, but that's the placeholder so I don't forget to have the appropriate pattern charge based on Mr. Tezera's decision to testify or not testify. And he and I will talk about that later.
Your Honor, I do have a question of one before that.
Yes, sir.
So like on credibility of witnesses, when there's a parenthetical, even though it's in a parenthetical, I don't want to assume you're going to give what's in the parenthetical.
Correct. The pattern charges in some instances have many parentheticals as a call out to the judge to say you should pick the ones that apply. I don't leave in anything that I won't be reading, because what you see here, once I get rid of the stuff that's highlighted and struck through, that's what will be printed out and given to the jurors, and it'll be what's on the screen. So in reading the credibility of witnesses charge, I will say the probability or improbability of their testimony. I just think it's grammatically correct or stylistically correct to have that in a parenthetical, but I will read, say those words, and it will be in the printed version.
Thank you.
Okay.
I'm gonna read up on parentheticals. I don't know why it's in one, but it doesn't matter.
Okay.
That'll be exercise for after.
There you go. Limiting instructions. I don't think I've given one. I don't foresee giving one. Mr. Peoples, was that your request?
It was, and no objection to it coming up.
Okay. Mr. Hirsch?
Your Honor, I put it in there really more so because I thought it was appropriate, and I mean, the reason I put it in there is because the bias evidence information was entered. You haven't given a limited instruction on it, but it was entered for limited purposes. I don't care if you give it or not. I put it in there because I thought it was appropriate. Since that's why I put it in there, I'll bring it to your attention.
Okay. I don't intend to give it, but we'll revisit when we talk one last time about the jury charge. Prior difficulties. I'm not sure who requested that. It doesn't seem like this case. I appreciate that there was a lot of testimony about, I will call them present, actual, immediate difficulties between Mr. Tezera and Ms. McConnell, Ms. McCall, but I don't, their relationship was so short. I don't recall there being testimony that, gosh, we fought like this before, and this is how he gets to be, or this is how she gets to be once someone grabs a marble tray.
Understood. And I put it in because of the sort of the, I guess, the way that law enforcement is called out because of the domestic issue. So understanding what the court's reasoning is, but we thought it might have been appropriate.
Okay. I don't intend to give it. Mr. Hirsch, any objection to prior difficulties being removed?
No, sir.
All right. Character of the defendant. I need you to tell me, Mr. Hirsch, what character trait or traits you're going to have character witnesses talk about. I had to do a bit of a refresher on character evidence and learned or relearned that it actually has to be a pertinent character trait. And this is not a case where I don't believe this one charge is one where character for truthfulness, for example, would be appropriate because it's not an allegation of fraud or forgery or deceit. It's not one where character for peaceableness necessarily, although I guess that would rebut Ms. McCall's testimony that Mr. Tezera got violent with her. So preview for me what the character trait or traits are, because you may not get to call character witnesses if I don't find that trait or those traits are relevant to the charge, which is trafficking in cocaine and not lying, cheating, stealing, hurting people.
Your Honor, I don't think that I'm going to end up presenting my character witnesses. However, I would like to finish this conversation with you.
Okay.
It used to be, at least, before Georgia adopted the new rules, I guess I shouldn't call them that anymore. It's been a while, but you could ask about truthfulness if the defendant testified, because you could ask if you could believe them under oath. If that's changed, I haven't revisited that aspect of the change in the law.
No, I think things are different should your client testify. And that's not what I was referring to. I think there's I don't disagree with you,
Okay.
but that's triggered by a defendant testifying. Not his statements come in, but he testifies. I'm not presuming he is or isn't testifying. That's an important decision he'll be making soon. But if character witnesses come in and say he's a super truthful guy and then he decides not to testify, then how do we unring that bell? It's not relevant. Jurors shouldn't have heard that. So that's why, but it sounds like you are stepping back from the notion of calling character witnesses.
I am, but while we're on it, I would like, I was going to make a motion at the time. We can save it because I do think it's not going to happen. But my also understanding is that the state can now not say, they used to say, hey, well, would you still believe that if you knew that, you know, he was arrested for X, Y, and Z? But now the specific, or just with any specific act, they could test the witness's knowledge or challenge if they still believe it. But I believe the law is now the specific act has to go to that character trait.
Correct.
Okay. If he testifies and I call character witnesses, we'll pursue that motion.
Okay, but if you're calling character witnesses, they would come after your client's testimony, not before.
Yes.
Okay.
I mean, the court I think is telling me that.
I
I obviously can't tell the court he's definitely going to testify because that's his decision. So that would be fine.
No. And that's why I said, if your client testifies, character witnesses, if any, would come after that, not before.
Yeah, I do. Yes.
Okay.
Just say yes. If, I have some scheduling and timing issues, but I'll bring it up if it comes up.
Okay. Got it. And Mr. Tezera, just a quick side note. You and I will have a conversation after the state rests outside the presence of the jury, but with your lawyer right next to you about whether you want to testify. It's a decision that you make. I will not ask Mr. Hirsch, hey, does your client want to testify? I'm not going to ask friends or family members who are here for you, hey, does Mr. Tezera want to testify? I'll be asking you. I'll be telling you your rights to testify and the consequences of doing that, and your right to remain silent, and what I'll tell the jury about that. But I just want to preview that that'll happen today. We will have that conversation today, and you'll need to be ready at that point to answer those questions. That won't be the time to say, hey, that's an important decision. Can I get back to you on Monday? You'll need to answer then and there, I am testifying or I'm choosing not to testify. Again, outside the presence of the jury. Okay? Yes? Yes. Okay, great. Back to the charge. Parties to a crime. Was that yours, Mr. Peoples? Okay, I think that's right. Do you agree, Mr. Hirsch? No need to charge parties to a crime?
Correct.
Okay, it'll be out. Weight. I don't believe I should charge weight. There has been no evidence that the weight of the cocaine was anything more than 200 grams. So I'm not sure what the evidence is. There has to be some evidence in the record to give a charge. Usually I bring that up with the defense because they want self-defense or something. And I say, but there's no evidence of self-defense. The guy was shot 10 times in the back as he was running away. So
are you saying that there hasn't been any evidence of what the weight of?
There's been no evidence that the weight would be less than 200 grams.
I see. I see what you're saying. Okay.
To me, the evidence was unequivocal that it was 295.04, or it was to the 100th of a gram, and that wasn't challenged. It wasn't the weight that Mr. Hirsch challenged. In fact, he didn't. The chemist stuff he didn't challenge. He cross-examined her, but I didn't get the sense he was saying that's not cocaine. He may argue to the jury there's no way to show that that's the cocaine that was found in the white bag inside the two red bags inside the cereal box, but that's doesn't go to the weight.
Okay, Judge.
All right, Mr. Hirsch?
Judge, I do disagree, and here's why. Is there are two separate bags of cocaine that are tested. And in and of itself, I don't know if that's enough for the jury to say, oh, well, maybe there are two different people's cocaine, one his, one hers, and that makes it less than 200 grams. But I have a better argument than that, which is they could accept the cocaine amount on the first sample that was tested in November of 2023. Then there was an error and they had to retest the second sample. They could question now because there was an error, because it failed 2 quality controls, whether that test is accurate as opposed to the first. It was tested later, it had already failed quality controls. If they were to do that, then the weight would be less than 200 grams.
I don't follow that argument. They tested the same, what Ms. Hutton testified to is that the very same, she dug out a little bit from each of the 2 bags,
Right.
tested that in, let's pretend it was November of 2023, got results, and then learned a couple months later, those are suspect because of a typo in a log, whatever that means. So as I understood her testimony, she retested those same 2 samples. She didn't dig back into the 2 bags of cocaine. So the very same samples she had withdrawn, she retested those, and her testimony was it's slightly better for whoever's drugs they were because they were slightly less pure. It wasn't that it became more pure, it was less pure. Am I misremembering? Because if I'm not, I don't understand how the retest would cause the jury to say the weight is under 200. They may say the results are ridiculous and we don't think the state has proven it's cocaine, but there's been no one said the scale was wrong, that had to be recalibrated. She used ounces instead of grams. It was always 295 grams.
I'll be corrected if I'm wrong, and maybe I am. I thought she just retested the second sample. I mean, I'll be on the crime lab.
She retested both because both numbers changed. It was again, making up, but one of them was 52.2 and the other was 50.6. And she had new numbers for both of those that were slightly lower, which is why she said it got slightly better. If someone was going to argue purity was what this was all about, it was slightly less pure, but she provided new purity results because that's all she tested again was the purity. It wasn't, is it cocaine? There was no error because you asked her, well, was it the HCl machine or the ABC machine? She said it was the ABC machine that just does purity. So I took those same 2, tested them again, and got purity numbers that were really, really similar to before, but slightly lower. No change in weight, no change in assessment that this is cocaine.
Yeah, I'll just say one last thing. I think the reason for the retest is because there was an error just on one of the 2 samples, the second sample. If that's the case, you could disregard what was tested 2 months later after it had been opened and only accept the first test. And if they only accept the first test and it had to be retested because there was a problem with B and they disregard 2B, the second bag of cocaine, then the weight would be less than 200 grams.
Okay.
And Your Honor, statement just say that the court's assessment is correct. Ms. Hutton, if I may, Judge.
You may.
Ms. Hutton did testify that she tested the exact same thing again, and it was within, I think, 2% or so of the purity, but the weight wasn't an issue. The fact that it was determined to be cocaine also wasn't an issue. And from my recollection as well, I believe that as the court's recollection as well was that it was over 200 grams, so we'd be fine taking that out.
Okay, I don't intend to give it. Again, things could change between now and both sides resting. But the evidence as I've followed it is raises a question of whose drugs were they? And did the drugs that were found in that hallway that night end up being the ones that she tested? Not what were those things or what did they test to be? So I will not give the weight charge.
And Your Honor, respectfully object.
Preserved. That's all I've got. Mr. Peoples, did you have anything you felt was excluded that should be included in the draft charge?
No, Your Honor.
Okay. Anything that's in there that should come out beyond what we discussed? Mr. Hirsch, same 2 questions for you. Inclusion and exclusion.
I thought I'd asked for 2 theories of guilt. Did you take that out?
So I didn't take it out. It maybe never made it in. Whatever you submitted, Ms. Niles poured over and asked me some questions about what's happening in the case, et cetera. And then she shared with me a draft, and I edited it in the way you all have seen. So I'm not familiar with the two theories of guilt.
Charge or am I requesting it?
No, I'll look at your charge now. I'm not familiar with the charge. Let me find your charges. Here they are. Let me stop sharing so that. Oh, you did exactly what, is that a non-pattern or a pattern?
All I asked for were patterns.
Okay. I'm not familiar with the two theories of guilt pattern charge, nor do I see it listed there, but it might have a different name.
All right, I'll take a look. Well, I'll look now.
My research team is telling me that you are showing your experience and that that's not a pattern charge anymore.
Oh, okay. Is it an acceptable charge?
I don't know what it says. So if you want to send it during a break, I'll look at it, and that can be one of the things we touch upon when we circle back to this after everyone's rested.
All right, you want me to tell you what it says basically, just so?
Yeah, if you'll give me a summary, if it's not really long.
Yeah, I think basically, no, it's not. If there are two theories proposed, the state would have to prove their theory but beyond a reasonable doubt, and disprove basically the defense theory beyond a reasonable doubt.
Okay, you can share with me the language and I'll let you know if that's something I'm going to include.
If it was taken out of the pattern charge, maybe it's no longer valid, but.
I don't know that
I'm seeing sorry, it says in my research that this charge was removed as a result of Langston v. State, 208 Georgia Ave 175, 1985.
like I said, he's very experienced. So since 1985, that's been a bad charge. In Fulton County, we're probably not going to give it, but if you want to share it with me and share Langston with me, I'll see whether we do that.
All right. Thank you.
Okay. I do feel like I adequately cover burden of proof that the state has. Anything else?
Nothing from me, no, Your Honor.
Okay. We will talk about the charge one more time after both sides have rested. If you need to freshen up or take a break, how are we doing with jurors? Okay. What's going on, Mr. Miller? Just coming to spectate?
I'm just coming to see how things go.
All right.
I'm also letting you know it.
Great.
How much time we have for a break?
We need to hear what the answer is. Missing 2, so you got at least 5 minutes. I will mute the microphone in here so you can speak freely. So I can get in here again.
That's good to watch the. Yeah.
All right, Ms. Rivers, are you ready? Great. Let's get back on the record, please. Mr. Peoples, we've got our jurors here. Is the state ready?
It's ready, Judge.
Okay. Mr. Hirsch, you ready for the jury?
Yes.
Bring them in, please.
What exhibit are we on? 28? What exhibit are we on? 28?
Double-breasted
Had to pull it out, Judge.
retro Peoples.
We're matching.
Yeah.
We're on a roll.
You're inverse.
I'll do the president account for.
Thank you, Deputy Gordon. Everyone may be seated. Happy Thursday. Welcome back. Appreciate everyone being on time. I hope the shift to 9:30, I have learned by working with jurors from all over the county that actually like a half-hour difference can mean my commute downtown was 40 minutes shorter, or it was worse because the traffic patterns are different. So I apologize if for some of you it was hairier because we started a little bit later, but we were able to cover all the things we needed to and then some, which means the state should be ready to call its next witness.
Yes, sir. State calls Officer Suk.
The Wi-Fi here. Morning.
Will you shake and raise your right hand? You swear to affirm that the testimony you will give, the truth, the whole truth, and nothing but the truth of God. Go ahead now, see. And you said it's better than the record?
Suk, spelled R-A-L-P-H, last name Suk, S-U-K.
Officer Suk, where are you employed?
It's Atlanta Police Department, City of Atlanta.
What is your position with the City of Atlanta Police Department?
I'm what they call an FOD, Field Operating Division, where I answer 911 calls.
Were you working in that capacity on June 11th, 2021?
I was.
Did you respond to any calls, any 911 calls later in that evening around like maybe 10 o'clock p.m.?
Yes, ma'am. It's the beginning of my shift.
Okay. What was the address of that call?
1888 Emory Street, apartment 265.
Is that in Fulton County?
It is, ma'am.
What did you do upon arrival?
Just make sure the scene is safe and then observe, see what's happening. The situation happened before I arrived, so before my shift. It happened on evening watch. So another officer, Philemon, was there on scene, but because she was getting off shift, I took over.
Okay. And are you post-certified?
Yes, ma'am.
Were you post-certified on June 11th of 2021?
Yes, ma'am.
Now you said that when you arrived, Officer Philemon was already there and you took over. What does that mean?
It's not uncommon for an officer to take over, only for the fact that she's already worked her 8-hour shift. And so it was just the beginning of the investigation. And so it was easy for me just to take over right there to let her go home.
Okay. And while you were on scene, what did you do?
Just collect the information to see what I have. I saw that Miss McCall was already just detained, just for the safety of herself and myself, because we don't know who's who and who the suspect or the victim is quite yet. So she already had him detained.
Let's
and
start there. What kind of call was it that you were responding to?
It was a signal 51, meaning that it was a stabbed person. So I saw large amounts of blood as I was walking down the hall, on the wall, the floor, throughout the hallway up until the apartment 265.
So tell us about that. Where did you first see blood?
Down the hallway after the elevator. It's been many years, but if I can recall, it was started right after the elevator, and as you're walking towards, you saw small amounts, and then it became larger and larger.
Okay, about how far from the actual apartment that this call was did the blood start, or the blood trail start, I should say?
250 yards.
Was it just the same hallway? Was it different hallways, connecting hallways?
Same hallway, yeah, from the main entrance.
Okay, so what is in this hallway as you arrive?
There, Officer Philemon, fire was already on scene. Grady hasn't arrived yet. Mr. Tezera was on the other side of where McCall was. I saw lots of bandages, latex gloves all over the ground, a large amount of like bags that were left on the ground.
Describe these bags for us.
Just small gym bags type. I believe there was a blue and green bag of some sort.
I'm showing you what's been previously entered into evidence as state exhibits 4 through 11. Can you rifle through or look through those photos and tell us if you recognize them?
Yes, ma'am. These are the photos. There's a blue bag and a green bag. Large amount of clothing, a laptop. Yes, ma'am.
Does that depict the hallway as you observed it when you arrived on scene?
Yes, ma'am.
Start with state exhibit 4. What is that?
This is the door to 265 to Miss McCall's room or apartment.
And state exhibit 6, what is this?
It's also, but just a different view of the same door. Oh, my apologies. This is 264, so it's the apartment across.
And state exhibit 7. Tell us what that is.
It's like the green Publix bag and the blue bag and the laptop, the shoes. That belong to Mr. Tezera.
And then 8, 9, and 10. Tell us what those are photos of.
8 is a photo of a basket filled with clothing items, some bloody white shoes, and a shoe box and some a sweatshirt of some sort. Exhibit 9 is also the same picture as before, green Publix bag, a blue bag, black laptop, and bloody white shoes, looks like Nike, and a shoebox. Exhibit 10 is the same, but at a different angle.
And then State's Exhibit 11, is that the hallway and the blood as you saw it that night?
Yes, ma'am.
You stated earlier that you arrived on scene and you secured the area. Were you doing investigation or were you mostly just securing the scene?
Well, the primary first thing I normally do is I make sure the scene is safe for all the officers and people involved. And then second is to get involved in investigation. But because investigator Skidmore arrived later on scene, I wasn't quite sure who was the primary at first. If I was going to take it from the officer or if the investigator would. But at any time, anybody can take charge of it. If someone took more notes and they were already involved in 30 minutes of taking notes or an hour worth, then most likely they would take it. But if they haven't really collected anything, and then I notify the supervisor. SOP standards state that I have to notify a supervisor whenever there's a physical altercation of some sort. And so I called the supervisor, and then at that time I advised him, or he can advise me if I was to take primary or if I would take primary, and I did.
You did take primary?
Yes, ma'am. And so at that time, and then normally you would, each officer that arrives on scene just takes different parts of a large crime.
And you said that Officer Philman was already on scene when you arrived. Was Investigator Skidmore also on scene when you arrived?
I don't know the chronological order if he arrived there on scene because it was a large area, but he did arrive on scene while Philman was on scene as well.
And who was, I guess, you said that everyone was investigating, but who was going into the apartment and speaking with most of the witnesses? Was that you or was that Skidmore?
Initially, we both did, but the hallway was filled with fire personnel and Officer Philman. And so at that time, it would be okay because there were someone to secure the scene. Then so we initially went inside together to talk with Ms. McCall. She talked about some type of oil and base and bleach and things of that nature. So we went inside to go look and ask more questions.
That you and Investigator Skidmore?
Yes, ma'am. And
then
then
who was outside from APD was outside in the hallway?
Officer Philman was still out there.
And then later on, did Officer Philman stay on scene the whole time?
No, ma'am. She had left. And
why did she leave?
Later on, I found out that at that time I didn't know where she went while I was inside. I didn't have great service for my radio, so I had to either go on the balcony or outside somewhere to get radio signal. And then when I was outside, she had already gone. But later, I found out that she went to the hospital with Mr. Tezera.
Okay. And while you were in the apartment and Officer Philman had left, was Investigator Skidmore in the hallway at that time?
I'm sorry, ask that question again.
Yes, while you were in the apartment trying to get service and Officer Philman had left, was Investigator Skidmore in the hallway at that time?
I don't remember.
Okay. Was there ever a time when the hallway was, after officers had arrived, was there any time when the hallway was not occupied and being watched by a law enforcement officer?
To my knowledge, that the property was never left alone.
Okay. Was there a time where Investigator Skidmore had gone into the apartment and you were alone in the hallway with the items?
Yes, ma'am.
While you were in the hallway with the items, were there any other uninvolved parties you tried to go through?
Yes, ma'am. Some other residents who lived in and around that apartment 265. They tried to come through the scene.
Okay. Were they allowed to?
No, ma'am. They were redirected to go around.
Okay, why is that?
Because ID hasn't shown or hasn't arrived on scene quite yet. And so I have to preserve the scene. And so they tried to walk through, which would disturb the crime scene. And so I asked them, it was a long walk for them, but they can still get back to their apartment.
And did any of these people touch or handle or manipulate any way any of the items that were in the hallway?
No, ma'am. And before they even could walk down the hall, they were stopped and redirected.
Did the items that you've already described that were left in the hallway, what is the law enforcement's procedure when items are left on scene like that?
If it's involved in a crime of this situation, yeah, nothing is not moved or touched.
Why is that?
Just to preserve all evidence. And then we wait for ID to come out and take pictures.
And then after ID takes pictures, what is ID? Tell us about it.
I'm sorry, it's the unit that comes out and just photographs and documents. Sometimes they take fingerprints, but mostly they take pictures just to, preserve the scene. And so.
Okay. Did you request ID to take any fingerprints in this case?
Generally, I'm on the bottom of the totem pole. I don't really tell ID what to do. They kind of generally know what to do.
Okay. So after ID takes the photos, what happens with these items? What happens to these items, I should say?
Then it's either myself delegates to tell another officer, hey, I've got to go do something. You take the property down. But in this case, the supervisor, Sergeant Stenson, gave orders to Appleton.
Your Honor,
Officer
here's
Appleton. I'm sorry.
Did any,
You're good. We're stopping. Why don't you reframe the discussion?
I'm gonna redirect.
Okay.
Did any other officers arrive to handle these items?
Yes, ma'am.
Why did they arrive to do that?
It's just normal, common, where other officers come to help.
So you had said something about collecting the items. Is there a APD policy about seeing what's in those items before they're taken to put into evidence or property at APD?
Yes, ma'am.
Okay, tell us about that.
Originally, I wasn't there for the bags. It's for the stabbing, and so.
Well, just tell us about the procedure about why someone would have to go through the items before they're brought in.
It's just for basic inventory. We have to categorize what's in the bags.
Okay, why is that?
I guess for numerous amount of reasons, just to make sure that what was there was put in properly, and just to have the correct. Sometimes the victim or the suspect would tell us, "Hey, I had like money in the bag. Where is it? Where's my laptop, my phone, my belongings?" But we didn't categorize anything. We just threw it in property, and then it goes missing or something of that nature. It's just to protect us as well.
Okay. You use the word property and you use the word evidence. Are they the same thing or are they different?
So in the beginning, it became property, and then once it's discovered that there was illegal substances, it becomes evidence.
So just the items when it was just the personal belongings of the defendant, it was just considered property at that time?
Yes, ma'am.
Okay. And when items are taken to APD, are they classified as either property or evidence?
It could be, yes. On the report, it gives you the option.
Okay, so something like clothes, how would those be categorized when taken to APD?
Some of the personal items that don't involve that he would like to pick back up, I put into property.
Okay.
I put it under the tab of property so he can pick it up, like his wallet, his watch. And if the investigator that further investigates and finds that the laptop was involved in that crime, then they will change it to evidence. but
Okay.
most likely it was property.
And then things like drugs or other illegal substances, are those categorized differently from the clothes or personal items?
As evidence, and the evidence never gets released again.
Okay, so does property get released to the owner?
It does, yes.
All right, so did you transport anyone to the precinct from this incident?
Yes, ma'am.
Who did you transport?
McCall,
Okay, that's Cameron McCall?
Cameron McCall, my apologies. Yes.
And did you create a warrant, issue a warrant for crimes stemming from this investigation and this 911 call?
Yes, ma'am.
Did you make the decision about what to charge each person with, or was that a collaboration among all the officers on scene?
It's a collaboration.
Okay. Let's go back to when you first were on scene. Who is the person that you stated was being treated by at first fire, Atlanta Fire?
Tezera,
Okay.
Manuel Tezera.
Do you see the person that you observed in the hallway that day in the courtroom today?
I believe it's this gentleman. It's right to my right in the blue light suit.
Okay. You already described the blue suit. Looks like everyone on at that table.
Light blue, black male, short haircut,
So there are three people. Is he left, middle, right?
middle.
Let the record reflect that the witness has identified the defendant.
He has.
All right, so when you left the scene with Ms. McCall, had the other officers completed the inventory yet?
No, ma'am.
Okay. Did you later find out about how the inventory went?
Can you rephrase the question?
Yeah, did one of the officers contact you about maybe something that they found during the inventory?
Oh, yes, ma'am. Later, I got a phone call
From whom?
from Officer Appleton stating that they found a large bag of white powdery substance and some marijuana.
Okay, and this was while you were in the process of issuing warrants for the crimes related to this investigation?
Yes, ma'am.
How did you decide to charge Mr. Tezera with the drugs and not Ms. McCall?
For a few
Objection,
reasons.
Your Honor, it's irrelevant why I charged them. It's probable cause standard and cause for opinion of the fact witness.
I'm asking what he did.
If you want to ask him the reasons why, his basis for probable cause, you can do that.
It's that was my intent. For
Okay.
what I'm asking, what are the reasons why you decided to issue warrants? Let's start with Mr. Tezera. What warrants did you issue for him?
Aggravated strangulation and intent to distribute.
What do you mean by intent to distribute?
Just for the fact that he had what was described to me of 338 grams of white powdery substances, large bags of marijuana, over 9 grams or 9 ounces, 9 grams, and then the amount of mushrooms that were also found as well. So it's from what I know about a little about drugs is that it's not a common, it's not the amount that one person would use. And then also he had a scale and small clear pouches, bags, a large amount of those as well. And those are signs of intent to distribute.
Okay, and how many drug cases would you say you've investigated over the course of your career?
I'm not a drug officer. There are units, the narcotics units that take care of those things. If there's ever a large amount, I would call them out. So I am not a narcotics unit. I'm just FOD where I just collect information, but it's very seldom.
So, how long have you been law enforcement officer?
Almost 8 years.
And, over the course of your career, have you, investigated 1, 10, 100? What would you estimate to be the number of drug crimes you've investigated?
Less than half a dozen.
When you were on scene, did you observe anyone with injuries?
Miss McCall, she had injuries on her neck. She had some marks that we discovered later when she described her that she was being choked. But that was found afterwards.
So earlier you mentioned that there was a lot of blood on the scene.
Yes, ma'am.
Do you know where that came from?
Mr. Tezera.
Okay. Why do you believe it came from Mr. Tezera?
Because he wasn't in handcuffs and fire was treating him,
Okay, treating him for what?
his wounds.
Were those like big wounds, small wounds?
I didn't see his wounds. Personally, I didn't go up. Generally, I don't get in the way of paramedics or fire. But based on the amount of latex gloves and gauze and everything that was already on the ground and blood, and I didn't see Miss McCall in, being cared, taken care of by paramedics or fire. And she was in handcuffs, and we generally don't put people in handcuffs when they're injured. And so because he wasn't in handcuffs, I just made the assumption all that blood and gauze and latex gloves and fire surrounding him, he was the wounded.
Okay. Did you see any, you mentioned that some bruising and maybe some scratches on Miss McCall. Did you see any large wounds on her that a large amount of blood could have come from?
No, ma'am.
I see you're wearing your body cam today. Were you wearing your body cam on June 11th of 2021?
Yes, ma'am.
And was it activated?
Yes, ma'am.
I'm showing you what's been marked as State's Exhibit 28. Do you recognize that phone drive?
Yes, ma'am.
Can you tell us what's on it?
My camera footage of that day and that situation.
I have no objection to foundation or substance.
Well, how do you know that's what is on that phone drive?
I viewed the body footage on it.
And did you initial it saying that you viewed it?
Yes, ma'am.
Are these your initials on State's Exhibit?
They are, ma'am.
It moves to admit State's Exhibit 28.
Sounds like there's no objection. It's admitted.
Wishing to publish.
Yep, just to manage everyone's expectations, are you playing the whole thing or bits and pieces?
No, sir, I'm just gonna play a brief. From when you first arrived to when the scene was, I guess, cleared, or the other officers were doing inventory, about how long is that?
It was towards the end. You're talking about the inventory when it was taken.
Yes.
It was towards the end of my stay there, so probably in the 2-hour mark, 2.5-hour mark, somewhere around there.
So the time you were on scene was somewhere between an hour and 2 hours?
Yes, ma'am. So it was less than 2 hours then.
Okay.
Because the entire video was what, about 4 hours and something.
And while you were in the hallway, were you securing the scene?
Yes, ma'am.
You stated that there were some people that tried to go through, but you didn't allow them to.
Yes, ma'am.
And when things are left in a hallway like that, is it police procedure to make sure that some law enforcement officer is always securing the scene and watching them?
Normally it's normal standard. Yes, ma'am.
Okay, and in this case, was a law enforcement officer always watching the hallway to make sure that, the items, in the hallway, the people in the hallway were safe and secure?
Objection, Your Honor, lack of personal knowledge. He said he was in the apartment during part of this time.
Okay, that seems like fodder for cross-examination. You can answer the question.
To your knowledge, was, the procedure of making sure that the scene was always secure, the people and the items on scene, was that followed in this case?
Yes, ma'am.
And while you were on scene, you say that a lot of what you did was to secure the scene and speak with some of the witnesses, but mostly you were securing the scene to make sure that it was safe and secure.
Yes, ma'am.
And you also mentioned that Officer Appleton contacted you about the drugs that were found.
While I was at the precinct getting the warrant, yes.
Because we're gonna start
2:03:49.
the body cam at 2:03, 2 hours, 3 minutes, 49 seconds.
All right.
I'm assuming you did, yeah.
Okay, so basically, it's on 2 large bags of marijuana and quite a large bag of really like white poppy substance. Sarge told me like to hurry up, get down to the annex like a wait. So you can like, so 3 feet, you're not able to charge, so.
Yeah, that's right.
Okay, yes, so I'm trying to get down to the annex, like, by like 1 o'clock, and then, I'll let you know from there.
I got it, I appreciate it.
Are you in the bathroom? Okay, glad you didn't pick up anything we didn't need to see. I would think maybe the body cam would shut off in the restroom.
No, sir.
So we can kind of see your phone in that. Did Officer Appleton send you a photo of the drugs that they found?
No, he just gave me a text message at the time, just saying the amount. That he gave.
Did you ever actually see the drugs that were found in person?
No, ma'am.
Did you perform any searches yourself?
No, ma'am.
And nothing further, second to redirect.
All right. Mr. Hirsch, your witness.
Morning.
Morning, sir.
All right, I want to start with the charges. You say you took out charges for domestic charges on my client?
For aggravated assault with strangulation, yes.
All right, do you have those warrants?
Not with me, no.
All right, when's the last time you reviewed them?
I mean, the last time I wrote them, yeah, was the last time.
Okay, how would I find those if they exist?
They can be printed out.
All right, and do you have the warrant numbers?
Not on hand, I don't.
All right, when you booked him into the Fulton County Jail, did you bring him there yourself?
I didn't, normally you do, but I didn't do it that night.
All right, when he was booked in, he was only booked in though on drug charges, is that right?
So he was booked on two with strangulation, aggravated strangulation, and possession of intent.
Okay, that's what you say, but do you have any documentary proof of that?
Not offhand, no, sir.
Okay,
Except my report. My report indicates that that's what he was arrested for.
all right, but ultimately, that is a conclusion that he was arrested for that, right?
So there was no other chain of command except myself.
Okay,
Primary, so I wrote the report and I did the warrants myself. But there wasn't a secondary person doing the warrants
Right.
and the report.
the actual evidence that he was arrested for something is, well, he's later on trial for it, he had to be arrested, right?
Yes, sir.
So I don't want the jury to get confused, and you know this, what one goes to trial on may be very different from what one is arrested for. I don't want to inject
My bad.
unnecessary procedural confusion here.
The actual evidence that someone was arrested for something is an arrest warrant, right?
Restate the question.
The actual evidence that someone was arrested for something is an arrest warrant, is that right?
Judge, I would object. I think he's asking a legal question.
It's overlapping. I mean, there are procedural. Maybe ask it a different way. I think you're entitled to explore this. He's told you, he put in his report, I arrested him for aggravated assault, strangulation, possession with intent to distribute. If you want to confront him with his report, say, where is it in there? You can do that, but
Right. I'm gonna hand you we're looking, now, when you go to the Fulton County website, when you go to the Fulton County website, you can find out what someone has been arrested for, is that right?
I believe you can.
Okay. We're looking at a document from that website, potentially refresh your recollection as to why he was arrested.
anything could refresh it. He's testified as to what he arrested him for, but if Mr. Hirsch wants to put something in front of him, Officer Suk can say that changes my mind. It doesn't change my mind. He's entitled to share it with him, but he should share it with you first.
All right, I'm gonna move on from that for right now. So while you're on scene, when you're on scene, are you there before Skidmore and Philemon?
No, sir.
Right, they get there first. And when they get there, EMS and fire are already there, is that right?
No, sir.
All right, EMS and fire come later?
No, fire is the only one on scene.
All right, is fire there before them?
Yes.
Okay, so fire's there first, they're the first ones there.
My
Go ahead.
apologies. I don't know.
Okay, good.
When I arrive on scene, Skidmore, well, Officer Philemon and fire were already there, so I don't know who arrived first.
All right, you're the lead detective in this case, is that right?
No, sir. I'm not a detective. I'm an officer.
All right, you're the lead officer on this case?
Yes, sir.
All right, so you're in charge of sort of compiling everything, making sure everything gets where it's supposed to go.
Normally, a primary officer does delegate, or if a higher ranking officer or an investigator comes in, they also can delegate as well.
Who's in charge?
Everyone that's there is in charge.
All right, is there any one person that's in charge?
The primary doesn't mean that I'm just all in charge. I just make sure that things are done the way it needs to be done.
Okay, so I won't say the word charge, but you're there to make sure that if something is not done, that it gets done, correct?
I'm one of them. Sergeant Stenson or Investigator Skidmore also are there as well to advise.
Okay. When you wrote a report in this case, correct?
That's correct.
But what your report is, it's not a supplemental report, it's an incident report, is that right?
That's correct.
And the supplemental report will come after an incident report, correct?
It can come from an officer, investigator, or anybody else, or if I find further things after I've already written my report and I need to add, and I can write a supplement myself.
Okay, so if anything basically happens after the incident reports are written, are the incident reports supposed to be written around the time of the incident?
It's supposed to be done Based on the crime, it could be 1 hour, 2 hour, or by the end of my tour of duty,
All right, and your tour of duty means what?
end of my shift.
End of your shift. So it's supposed to be done pretty much, certainly within 12 hours of the incident.
Within that 8 hours.
8 hours, okay. And now a supplemental report might say, go back and put it, excuse me, put everything together, say there was a subsequent interview with a witness or the crime lab results, come back and put it together in a nice packet. Is that right?
Generally, yes.
All right. And in this case, there is no supplemental report, right?
I don't recall any other supplement report besides Officer Foster. While he did a supplement report just claiming that he was advising that he was putting in drugs.
Okay. So his supplemental report is just having to do with the transport, the finding and the transport of the drugs.
Yes.
And you also don't do the GI report, right?
What's the,
That was going to be my next question.
okay.
What is the GI report?
General investigator.
All right. What's that mean? Excuse me.
Each watch is a little different. Morning shift is, we start our shift at 10 o'clock or 11 o'clock. And so we don't have the resources that day and evening watch has. We don't have ag assault units, homicide units, any other specialized units. We don't have availability. So when I start my shift, the only person that's available is the general investigator, and he covers everything.
All right. And who's the general investigator in this case?
So the only investigator that was there, he didn't get called out. He just heard it on the radio, was just Investigator Skidmore. He was in the area, so he decided to stop by.
Okay. So he's the general investigator in this case.
Yes, sir.
All right. So if you don't do something, that needs to be done, whether it's follow up with witnesses, get a search warrant, look at video, that's something that he would do.
That's beyond my scope. I don't question what the other units do and what they do or how they do it. I just do what I'm supposed to do, is just collect information and hand it.
All right. Is there anybody who oversees what every little component is doing to make sure we have one solid investigation, who knows what all the reports say?
I'm sure there is,
Okay.
Yeah.
Great. Who's that person?
that I don't know.
But that person exists on this case?
So I understand what you're trying to say, but the information I do not have.
Right.
It's based on, it could be an investigator from zone 1 that picks up that case. It doesn't have to be from zone 2. It could be an investigator that's lighter on cases than the other one, and one would pick it up and then take over and then investigate further by going into body cam. But there isn't one specific person that overwatches all the hundreds of thousands of videos and cases that come out that particular month. There isn't.
Well, I'm not talking about cases in a month. I'm talking about in a single case.
So
All
the
right.
same thing, that it's you don't know. It doesn't assign to one person. Anybody can pick it up.
Okay.
So,
You talked about injuries. Ms. McCall said that my client threw bleach on her, correct?
that's correct.
All right. Did you see any injuries associated with bleach being thrown on a person?
Not on her. I did not
Okay.
at the time.
Did you then say, hey, how come there are no bleach injuries on you?
What does a bleach injury look like?
Maybe smell, touch, and sight. But I did smell bleach inside. From what I understand, that Tezera also stated to Investigator Skidmore that she threw bleach on him. So I couldn't determine who did the bleach or not, but I did smell bleach in the apartment.
All right. You're outside in the hallway with Cameron McCall for 30 minutes or more. Is that right?
So
All right. And you never smell bleach when you're not in the apartment, when you're in close proximity to her. Is that right?
I didn't smell any bleach on the outside or anywhere on Miss McCall.
All right. And when you went into the apartment, did you see any signs that bleach had been thrown on the couch?
Since bleach is a clear substance, I couldn't see any stains of any sort, just the smell.
All right. Bleach does bleach things, right?
I'm not a chemist to indicate how long bleach has to be on something in order to change the coloration.
Have you ever done laundry with bleach?
I don't do laundry. My mother-in-law does.
You've got a good gig, Officer Suk.
Good for you, I guess. I don't know.
Yeah.
But we certainly know you're candid. All right, so was there any evidence about bleach being thrown on her $50,000 Louis Vuitton shoes?
Not that
Judge,
I can
I
indicate.
object to lack of personal knowledge.
I don't know. I didn't see any coloration, if that's what you're asking, or any damage to shoes or couch of any sort. I just smelt it.
All right, and you smell it, it appears as though someone has been cleaning up by the time you get there, right?
That I don't know. I can assume that.
Okay, well, I'm not asking you to assume, I'm asking you, Miss McCall was in there, right? In the apartment with you when you walked through it?
Yes.
I know. That might be it. The number is, yeah, I gotta change the number. Okay. Let me change these numbers. I'm gonna hand you what's been marked as offense 13, 14, 15, 16, 17, 18, 21.
13 through something and then 21, 13 through
18.
18, okay. And 21.
If you just take a look at them, if you recognize them, just look up and let us know.
Yes, sir.
All right, and do you recognize those?
I've never seen these photos before, but yes, it seems to be consistent with that night.
All right, so does it appear to be a true and accurate depiction of what the inside of her apartment looks like when you walk through it?
Yes.
All right, I'll hand you what I've marked as defendants exhibit 23 and 24 as well. Same question.
Yes, sir.
All right, do those appear to be a true and accurate depiction of what you saw that evening?
Yes, sir.
Okay. Your Honor, at this point, I move to move stage 23 and 24 into that.
So it's defense exhibit, but it would be defense 23 and 24. What about 13 through 18 and 21?
Thank you, Judge. I would like to move those as well.
All right, Ms. Nix, any objection to defense 13 through 18, 21, 23, 24?
No objection.
All admitted.
Okay. Now I'm going to show you defendant's exhibit number 13. All right. Does that appear to be, it looks like blood is being cleaned up, right? Okay. Well, sorry, go ahead.
I don't know if it's people walking or whatever, so I'm not sure.
Okay. Did you specifically go and smell that area to see if it was being cleaned with, if it was with bleach or anything else?
Just a normal walking through. I don't tend to bend down and smell,
Okay.
but just generally walking through, I just smelled bleach. That's all.
Is that something crime scene would do then, to smell it?
It's beyond me. I don't know what crime scene is.
All right, and those are brooms and the mop there?
Yes, sir.
All right, does that appear to be, are their devices used for cleaning? All right, 15, that's just blood splatter on the wall or on the door? Okay, and that blood splatter, your investigation shows that the only one who was bleeding was Emmanuel Tezera, is that right?
From what I believe so, yes.
And you were standing face to face with Karen McCall in the hallway, within 2 feet of her for over 30 minutes, right?
I didn't see any blood on her,
Okay.
not
And-
from her persons,
Okay, and her demeanor was calm?
half and half.
Okay. So at first she's very upset, right?
Yes,
Right. She's upset because she's being treated like a victim.
I can't tell you what her emotional state was. I don't know.
She says at some point, her and Skidmore in particular, she's real upset with Detective Skidmore, Officer Skidmore.
Yes, sir.
And then she says something about, hey, when trans get killed, you don't care about that, but you care about this. You recall that?
I don't recall that.
All right, and then he walks away, and at some point now you're left alone with her, right?
When she does go kind of off the wall, yelling, screaming, cussing, I don't want to talk to you, Skidmore, anymore. And then I try to use voodoo, judo, verbal judo type thing to calm her down a little bit. And so it does, but he's still there at that time. But later on, there's some more people that are arriving on scene that he leaves, either go talk or to let that person in.
Okay. You de-escalate the situation, right?
Yes, sir.
With your Jedi mind tricks.
I wish I had Jedi powers. But
You're just nicer. You know how to talk to her, and she responds, and you can calm it down.
yes.
Okay. And then thereafter, though, her demeanor, and this is, well, the video show, but this is after she says the thing about Ken. Skidmore also calms down, and now Skidmore and her can have a cordial conversation. Is that fair?
Yeah,
Back
I
to
guess.
speculation.
I'll let him overruled.
You can answer.
It's more so, is that what happened as opposed to were they capable of doing it? After people calmed down, did Investigator Skidmore and Ms. McCall have a more productive civil exchange?
Yes, yes.
Defense exhibit number 16, does that again, as opposed to like 15 where there's blood splatter, does that appear to have been cleaned in some manner? Wiped up?
I don't know if it's smudges or cleanup. It doesn't indicate, but
But this is on the counter, not where someone can walk, right?
it's
Or unlikely to walk on the counter.
not walking on the counter, but the counter is in the center of the apartment.
17 is just a different view of the box by the island. Is that right?
That's correct.
Now, at some point, do you recall Miss McCall telling y'all that she was soaking up the blood with Mr. Tezera's shirt or with a shirt?
I don't recall that.
All right, let me show you what is been marked in defense exhibit number 23.
Sure.
Now that I show that to you, do you recall walking through and she said she was soaking up blood with the shirt? If you don't, it's fine.
I don't recall. The only thing I recall is that she stated that Tezera asked for a shirt to wipe his blood off.
I'm gonna show you defendant 24. Do you know what that gold thing is on the ground? Does it look like, I don't know, is that large enough to be a marijuana grinder?
That I don't know. I don't know what a marijuana grinder looks like.
Well, then you're not gonna know
Yeah.
if that's what it is.
I don't know what it is.
All right.
So who's responsible for collecting these items?
Generally ID does.
And in this case, who would be the person to make sure that they did that correctly, that they picked up any items of value?
There isn't one person to make sure that other people do their job. It's just, they just do their jobs.
All right, is there anyone who's supposed to say, hey, let's see what CSI did, let's follow up on it?
That's beyond my scope. It's beyond myself. I don't make any follow-ups on that.
All right, I think you said you're the low man, you're at the bottom?
I'm at the bottom of the totem pole.
Okay. But you're the one who appears to be as much of a lead investigator as anyone in this case, right?
Yes, sir.
Right. Is that normal for them to take the person at the bottom and put them over the investigation?
If I was to be primary, yes. If I was to come on a crime scene and even if the chief was to show up, I'm still in charge.
Right. So being in charge, did you ask CSI to fingerprint anything?
No.
You did not ask them?
So generally, the investigator or the ID person is higher on the totem pole than myself. And generally, you don't tell your boss what to do.
Okay, who is that person in this case?
So we've gone around and around on this.
I'll
Who that person is, he's answered. Ask one more time and then don't ask him again, please. Who the person was in charge?
I didn't ask the very question, Rob. Who is the person whose responsibility it is in this investigation to make sure CSI does to ask CSI to do the fingerprints?
Asked and answered.
You can answer it.
So ID is normally the one who takes care of his own job. So whatever part that you play in is you just finish your job up to that point.
Okay, what's that person's name in this case?
It's ID unit. Please forgive me. ID unit Turner, his 4-digit is 7303.
So an officer ID unit Turner. Right. Was there a knife found in the apartment?
It was.
Okay, and what happened to that knife?
According to, it was turned in as evidence.
Okay, and you know that because you have an evidence log, is that right?
Yes, sir.
All right, so in the evidence log, my client has about 8 prescription bottles. There are 8 prescription bottles or so with my client's name on them.
That I don't know. I wasn't the one collecting it. I don't know if his names were on that bottle or not.
Were you there when Officer Foster and Officer Appleton were going through the bags?
No.
So that's called the inventory search of the bags, right?
It's just, we just take inventory just to log it, yes, sir.
Okay, but when they were doing the inventory search of the bags, you were not there, correct?
Yes, sir.
All right. Do you testify at a hearing on or April 18th, 2024 in this courtroom about this case?
Was it the suppression hearing?
Yes.
Yes.
All right. Do you recall being asked the same question about, did you remain on scene until after the other officers came to do an inventory search?
I don't remember what was spoken at that day.
Okay. Now that I read it, were you there? Okay. So you were there till they came, but not necessarily till they finished.
They already had left the scene and collected that information based on the video that you saw while I was in the bathroom.
So you were there when they were going through the bags?
No.
Were you there when they showed up? Hey, Foster, hey, Appleton, and then you left the scene? You don't recall seeing them at all during your time at the apartment complex?
I saw them there, yes, sir.
Okay, you saw them and then you left. We know you're in a bathroom somewhere else talking to Appleton. Okay.
My client's laptop computer was collected and put into evidence. Is that right?
That's correct.
All right. When you guys went through it, what, if anything, did you find?
I didn't go through that one. I didn't go through any of the inventories.
Okay. In this case, who was the person assigned to go through the inventories, if you know?
Appleton and Foster.
Okay. Cameron McCall's phone. She was cooperative with you, right? At the scene, at the end?
Towards the end, yes.
All right, she, after you guys talked about search warrant, she then let you guys back in the apartment, right?
Yes, sir.
You had possession of her phone, specifically Skidmore took possession of her phone, correct?
Don't recall.
All right. Did you go through her phone to see what was in there? Ask for permission or get a search warrant?
I did not.
Okay. Do you know who did, if anybody, in this case?
I don't know.
Did you go down to the hospital?
No, sir.
All right. Emmanuel Tezera's phone is taken by Officer Skidmore, right?
Object to lack of personal knowledge.
I don't know that either.
It's in evidence.
Well, I don't know what you mean by in evidence. If someone else testified to it, someone else did. He's saying he doesn't know.
Okay.
If there's a document you want to show him, have him look at the document.
You did not ask for consent or get a search warrant to go through Emmanuel Tezera's phone, correct?
Personally, no, sir.
All right. And as far as you know, as the person on the bottom who's the lead, no one else did. Is that right?
That I don't know.
Okay. Did you look at the 13-second video ring video that Miss McCall eventually shared?
I remember listening to it.
Okay. Do you remember watching it or you didn't watch it?
I don't remember, but I remember her trying to show me the video and I listened to what was being said, a lot of yelling, cussing.
Okay. You said that you put stuff into property and there's a log of it to help protect y'all, right?
I didn't turn in the property, but yes, that's the normal procedure.
Okay, so of all the bags put into property or evidence, there should be a log of what was in them, correct?
Yes, sir.
All right. Where's that log?
So generally, that's what's put in the report, so it indicates like a watch was put into evidence by Foster, a brown wallet, a belt. It indicates who put it in, and then the drugs, and so on and so forth.
But as far as what's specifically in the other bags, it's just listed as clothes, is that right?
Some of the general stuff that are non-liquid or dangerous chemicals, sometimes if it's just general items, we just put in one bag and put general merchandise of some sort. But it has nothing to do with the case. Generally, that's how it's handled.
You went down to the station with Miss McCall, correct?
That's right.
There was no statement. She did not give a statement at the station, is that right?
No, sir. Not that I recall.
Okay. Any statement she gave was at the scene?
Statements were done at the scene, yes, sir.
Miss McCall actually does a little bit of a demonstration for you about how she was choked, right?
You have to answer out loud.
Yes, sir.
Okay.
I was trying to think.
That's okay.
Oh, then don't say yes till you've thought through it.
Yes,
Okay. And she says that she was in a headlock, right?
yes, sir.
And that she was trying to wiggle free, correct?
Yes, sir.
Now it says his finger, her hand was on her throat, correct?
So the chronological order of when she got strangled or headlocked, and when the bleach or any of the other situations that happened to her, I wasn't quite sure the actual chronological order itself, but I could only write and put in the report what she stated to me, but I don't know what that order is. If she was strangled first or put in a headlock, or if they were both the same.
And you said, in answer to the state's question, you're the one who took out warrants on Emmanuel Tezera, right?
That's correct.
And you did that based upon what you saw, right?
Yes, sir.
Of course, you weren't there and there's no video of what happened, correct?
That's correct.
So then you base it upon other officers' information they give you.
That's correct.
And if they give you information which are assumptions, then you base it on their assumptions, correct?
I wouldn't say assumptions. If an officer tells me this is what he has, I generally just take it that.
Did Officer Skidmore ever later tell you that his basic assumption in this case, that my client took a book bag with drugs in it, turns out to be wrong? Did he ever tell you that?
Oh, I don't know that.
Thank you, sir. Nothing further.
Ms. Nix, any redirect?
Yes.
Officer Suk, can you tell us what you know about the difference between a warrant and an indictment?
A warrant is what I have if I have probable cause. I need a probable cause to ask the judge for a warrant to cause them to stand before the judge. And then once a ruling is done, if they seem that they have enough to indict him on that crime, then they go further than that.
Do you write the indictment?
No, no.
Do you know who does?
I'm assuming the courts or the investigator or some sort, but it's beyond me. I don't know beyond that.
Okay. Why wasn't it you that took Mr. Tezera to jail, even though you were the one that got the warrant for him?
Generally, that's why other officers come out to help, so we can finish within our 8-hour shifts. if other officers are free to help out, to just take evidence down, and someone takes them to the hospital and then I go out for the warrant. If not, it'll take me 100 years to finish everything all at one time.
So all law enforcement officers, you mentioned that you were post-certified. And are all officers trained how to respond to calls
Generally, yes.
and how to conduct investigations or the protocols of what to do on scene?
Generally, yes.
Okay, so if you arrive on a scene, you know what to do. You're not having to wait for someone to tell you what to do.
Someone who has seniority, been on for 3+ years, I'm assuming, it's just my opinion, that they know generally what to do. They've handled enough cases and situations where they know what to do. But some people who come straight out of the academy, sometimes you just have to instruct them because they're nervous or their adrenaline's pumping and they just haven't done it enough. So they do need instruction, even though they've been trained in it. They just don't have the experience sometimes.
Okay, but you stated that you've been a law enforcement officer for 8 years?
Nearly 8 years.
So in 2021, you've been a law enforcement officer for about 5 years?
Yes.
And when you arrived on scene, you knew what to do?
Yes, ma'am.
You knew what protocols to follow?
Yes, ma'am.
And in this case, were all protocols that the officers are required to adhere to, were they adhered to?
Yes.
Now let's talk about a GI report. Is that a term that y'all use?
It's just short for general investigator.
Okay, is it
It is,
general?
yes.
Sorry, go ahead.
Yes, it is a term that we use.
Okay. Is a general investigator case specific, or is that like a title that a specific officer has in the department?
No, it's not a specific title, but we only say general because morning shift, there's no other units for us to call on. Like if there's a rape or a homicide, there's specific units just for that. But on morning watch, we don't have that luxury. So that general he's an investigator, that's his title. He just generally covers everything.
Okay.
Rape, murders. And
So a general investigator doesn't have any kind of specialty. It's just if something comes up, they're the investigator.
All investigators are slightly different based on their experience and what they've been trained on. I don't know what Skidmore's training is on.
So you said that this happened on a shift where there's just general investigators. There's no specific. There's no like SVU
Right.
type investigators.
But generally, they could come out if we wanted them to, and we, a supervisor of some higher rank was to give an order for that unit to come out, like an ag assault unit. So Sergeant Stenson did call somebody to have ag assault come out because an aggravated assault or an aggravated battery did happen. So as a supervisor, he was supposed to call who he can to bring more resources in. But for some reason, we were denied because it was right at the end of their shift.
And is an investigator assigned to every single case?
No. Let me rephrase that. So generally, when it's a Part 1 crime, forcible felony, a felony, or a high misdemeanor, then we do call them. If there's enough, I would call them at least. Sometimes they don't come out, but sometimes they do if the crime is high enough. But eventually, on the report, it does reach the desk of an investigator, but they don't come out every time we have something.
Okay, when it reaches the desk of an investigator, is an investigator always assigned to continue investigating?
I don't know that, but generally, yes.
And does every case get investigated by an investigator?
If they see enough to where I can't really testify the mind of the investigator. I've never been one myself, but from generally what I know, if they have enough as they read it, they would follow up, yes.
Okay, so if they already have enough evidence for probable cause to get, to make an arrest, if the officers on scene gathered enough evidence, would they continue to investigate?
They could, yes.
All right, nothing further.
Mr. Hirsch?
You said all policies have been adhered to in this case?
To the best of my knowledge, yes.
All right, and you're judging that from the person who's the low person on the totem pole, right?
Yes.
All right, are you familiar with the policies on how you submit evidence to the crime lab?
When it comes to drugs,
Yes.
Objection outside the scope of, actually, no, I'll withdraw.
Continue.
Go ahead.
I'm pretty versed in it.
All right.
When it comes to drug intake, yes.
All right, and one of the things the person packaging it puts in a brown bag, right?
Each drug is done separately or differently.
One might, depending on the drug, put it in a brown bag such as stage 21, right?
Yes, if it's small enough to fit in the bag, yes.
Okay, and then one of the things they do, they put these labels on it.
Yes.
All right, they staple it.
Staple isn't really the norm, but it can, yes. To see
Okay, they then put this red evidence tape on it, right?
Yeah.
All right, and then they initial it here to make sure the red evidence tape wasn't tampered with, right?
I wasn't trained to put the initial, but if someone does so, I guess that's just extra.
Okay, and they do this at the police annex, right?
That's correct.
All right, and then at the police annex, if like the computer's here, there's there's a property. Is there a property window or evidence window at the police annex?
There is one, and there is also the lockers.
Okay, and if the computers are where the jury box is, then the property window is where the bench is, right? The next wall perpendicular. And yes.
Oh, yes.
All right, and then over here, opposite where the computers are, those are the property lockers, right? The evidence lockers for drugs.
No, sir.
Where are they?
They're behind you.
Okay, fine, they're behind me, but they're in the same room.
Yes.
All right, and the way it works, it kind of works like a mailbox. You can slide it in the slot and it deposits, right?
Some drugs are done that way.
Okay, let's say cocaine, suspected cocaine, is that done that way?
From what I know about that, you do have to open the locker,
Okay,
the door.
once you open the locker, then the next folks who are supposed to take it is the crime lab, is that right?
You push the button to lock it. No one else could put any more evidence in that locker. And then on that side, I've never been on that side, but that's what the investigator or the person in charge of that will take it up to somewhere. I don't know. That's
Okay.
beyond me.
But it's super important to put that red evidence tape on it before it goes into the locker, right? That's the whole point of the red evidence tape.
Generally, yes.
Can I play the last video from yesterday? This video.
It's up there.
Good.
Judge, the defendant is, I guess, intending to play Officer Appleton's body cam, and Officer Suk was not there when this occurred about Officer Appleton taking in the drugs to this evidence locker. And these questions would have been much more appropriate to ask of Officer Appleton, who testified yesterday. And so
But that's in evidence.
it is an evidence.
Okay, so
Officer Suk does not have personal knowledge of, I believe, the questions that,
why don't you ask a few more questions so we can see if the video is appropriate to play? Because it's almost like a refreshing recollection, but he wasn't there.
So you testified under oath that all, after the state asked you on redirect, if all policies were adhered to in this case, correct?
I did say that.
All right. And one policy is to what we just talked about, how you take the drugs, put red tape on it before you put it in the lockbox, right?
Okay, so generally, when a report's finished, said and done, and I see that the report, there was a evidence put in and a property module form was formed, and I see that who put it in, property and so on. Generally, that's what I'm looking for, just to make sure the property was put in. The details of that, if they misspell something, or if they didn't put a tab and they didn't do the correct tab, if they stapled it or not. I don't really go into that detail to follow up to make sure that all the details were taken care of. I just make sure that the evidence was turned in. How that officer does it, that's up to him,
Okay.
if he does it properly or not. I don't go further than that to call him up to make sure that he did every single dot and tittle.
I understand what your job is, but you testified that the policies were adhered to. You know what the policy is, right? With the red tape?
Yes, sir. The
Okay.
evidence was turned in.
And if you saw how it was done and it wasn't done by policy, you could say, I was wrong when I said policy was adhered to, policy was not adhered to, right?
If I saw the evidence was turned in incorrectly, I would tell you that it was done incorrectly.
All right, this time I'd like to show him the Appleton's.
Do you know right where to go on the video?
Absolutely.
Okay, let's do it. So this is states 27.
And I'm just gonna renew my objection just to the fact that this witness has no personal knowledge, and I believe that what he testified to was that, to his knowledge, all protocols were adhered to, and I believe that my question was on scene, if all.
It was, and you'll be able to, we're not going to redirect this witness, but you'll be able to argue later. But this video is in evidence, and the jurors are free to watch it. And I'm going to allow, as long as this is not very long, we'll play it. States 25. If you can tell the state where to go.
Yeah, 3 hours, let's go to 3 hours and 21 minutes. And then after a minute and 30 seconds, I'll jump one last time.
You know, one more time, 3.
Yeah, thank you. 3 hours and 21 minutes.
3:21:00.
Yeah, thank you. And Your Honor, again, I'll say it in closing, but I appreciate the state doing this. It's not their job, but helping with technical issues. That's fine.
This is 3:21:01.
Even here. Yes. First of all, don't hate. It's all good. It's all good. I found it. It don't matter. I found it though. I'm the one who did it for it. Found it. Don't go with it, baby.
Okay. We apologize. And I'm pausing it 3 hours, 22 minutes and 58 seconds. All right, you saw him put what appeared to be the cocaine and put it in the bag, right?
Yes,
All right, and this has already come in, that's Officer Appleton, you understand that?
yes.
All right. Would you all play 3:36:20, please?
Three 26:21.
Thank you. Now, does locker 06, does that appear to be sort of like a mailbox, more like a mailbox that you put it in and then you can't retrieve it?
I can't really see, but it sounds like he's squishing it in a tiny,
Okay.
tiny hole. Oh, yeah, I see it now. Yes.
And when he's at the annex on this job, he's only inventorying one case at a time, right? You can continue if you want to.
It's just really loud. It's hard to
Okay.
hear him answer your question. So
right.
if you're gonna ask, we'll pause.
Oh, wait, go ahead and play, sorry. Thank you, please.
Hey, so I have an unknown type of drug. We don't care. Cause yeah, so I think this is mushroom. I'm not sure. So I don't want to just. Yeah. It's oversized drug. This. Yeah. Take all over here. Yeah. And then got the cocaine. Like body substance, doing the same thing. Oh no, this is right here.
Officer Suk, you've not seen that video, that body cam before, have you?
I've never seen it.
All right, based on the fact that, it's in evidence, he's logging this case, right?
Yes, sir.
All right, there are 3 bags, one for suspected mushroom, one for a green light leafy substance that could be marijuana, right?
Yes,
And
sir.
one for suspected cocaine, right?
Yes, sir.
Object to lack of personal knowledge about what was going on in this video.
I was asking in the case of these what the 3 drugs were, that he's inventory.
Okay, but he wasn't in this video, and so he's not in a position to say this was our case.
Okay.
If you want to ask him something specific about what was in that video, as opposed to him speculating that this wasn't Appleton on a different day.
From the state's body cam footage that we just showed you, the state's exhibit rather, you saw 3 bags go into evidence, correct? Into the lockbox.
From what I see from the video, yes.
All right, and Officer Appleton says one is not unknown, but could be mushrooms, right?
Yes, sir.
He says another is marijuana or suspected marijuana, correct?
Yes, sir.
He says one is cocaine, correct? Or suspected cocaine,
White powdery substance, yes.
right? And then none of those bags, they all go into the lockbox, and when they go into the lockbox, they're supposed to have red evidence tape on them, correct?
How he handled his procedure, I don't know how he did it, except from what I see from the video. And he didn't put red evidence tape, yes.
All right, so none of those 3 bags was the red evidence tape, correct?
Not that I saw, yes.
All right, and once they go in the lockbox, he doesn't have access to it again, does he?
You can't retrieve them, yes.
You also saw on those brown paper bags, a sticker, right, that APD puts on the bags, correct?
I didn't see that in.
All right. And that sticker is to identify it, if you understand there are stickers put on these bags, right?
The only label that I put on, or Appleton would put on, is the larger square one. The small, little tiny one that's, 5 millimeters and so on, 4 inches wide. We don't put that on there.
All right.
That's not us.
Once it leaves the lockbox to somehow get to the GBI, you do not know who takes it there, correct?
That I don't know.
And if red evidence tape wasn't put on the brown paper bag, you don't know who put it on, correct?
Beyond that, I don't know.
Right, and you also don't know what happened to that bag, whether it was opened or not, between here, the annex, and the Georgia Crime Lab.
I don't know that either.
All right, and the purpose of the red evidence tape is to make sure that the tape seal is not broken, correct?
That is correct.
Because if it's broken, whatever's in there could be taken out, replaced, tampered with, etc., right?
That's correct.
In other words, the chain of custody would be corrupted, correct?
That I don't know beyond me.
Thank you, sir. Nothing further.
Jurors, do you have questions for Officer Suk? If so, cards to Deputy Gordon. Thank you. Ladies and gentlemen, why don't you take a quick break while I cover these questions with the lawyers. We're going to stop for lunch noon-ish, which means this is your time to take a quick break while I talk with them. Don't talk about the case, no outside research. We'll get you back in here once we're ready. You guys coming? Let's go. Oh.
We thought we were going to jury room, sir. Or, sorry, auxiliary room.
Oh, right, because they're on break. I didn't think about that. Let's go that way. Forgot we do that. Let's go this one.
Next. Cashews, Brazil nuts, pistachios. Cause I have. I need to use, I think almonds, the almonds are good.
Okay, good.
Jurors ready? Okay. Let us know once they're ready.
All right, adjourned. Bill President, time for.
Thank you, Deputy Gordon. Everyone can be seated. Officer Suk, a few more questions. Mr. Tezera left the scene that we've been watching on all the videos and went to Grady for treatment of his wounds. Was he arrested there? Where was it that he was taken into custody? Because you took out warrants on him. Do you know where he was taken into custody?
At Grady, I believe.
Okay, and some officer or officers transported him from Grady to the county jail.
I'm not sure if it's APD that transported him or not, or if it was the next shift that took him. He could also be transported by corrections as well.
Okay, it wasn't you.
That's correct.
All right,
But if I may clarify.
please. And if you get a little closer to the microphone. Thank you.
On my video, it stated that I made a statement to Sergeant Stenson saying, I'm not sure if Officer Filliman knows that he's now arrested, because it changes how that person is in custody at the hospital. If he's in handcuffs or not in handcuffs. If he's not handcuffed to the bed or put into a special area where a different doctor sees him versus the general public.
Okay, and this would have happened because you swore out the two warrants you described, the aggravated assault, strangulation, and the drug allegation. That's what would have changed Mr. Tezera's status at the hospital?
That's correct.
Okay.
That me advising Sergeant Stenson that he is now in custody, not detained, but just in custody, was at the scene when I had advised him.
Okay. Did Investigator Skidmore ever share with you any notes or any writings of his to help you author your police report?
Not that I can recall. I wrote my own notes.
Okay, and that was that in your recollection and your body cam would have been the basis for the report.
That's correct.
Did any other officers who were involved in any way with the situation provide you with any written materials that you used to make your report?
Not that I know of, besides the information about the amount of the weight.
Okay. Tell the jurors what you mean when you say a crime scene is secure.
Just basically not allowing people to come on premise, making sure that all the evidence is secure and not moved. Like say, for instance, if there were shell casings from a bullet, they're not to be moved. If there was a gun, if there was a knife, if there was some type of evidence of any sort, just anybody who's not involved, who doesn't live there, is not allowed to come on premise. That's pretty much it.
Can you share with the jury again, when you were answering some of Ms. Nix's initial questions, you described the blood trail, whatever you saw in the hallway, that external hallway outside the apartment, as a certain length. Can you share with the jury again how long you felt that was?
From the elevator, there's a divider. That 1888 Emory is divided into, I believe, 3 sections. There's building 1, 2, and 3, but they're all connected. I was going into the next section. So there's the elevator and then the divider to that next section. After that next section, if I can recall, it's been well over 3 years. But if I just remember seeing blood after that divider. It was very light. And then as I gradually went towards the door of the apartment of 256, it just the amount became more. But is that?
I mean, the question was for you to share again how long you felt this. So if you start at the elevator and you see a little bit of blood, and you see more, and then you ultimately get to the apartment, how long would you have been walking to cover all that ground? 10 feet, 100 feet, a mile?
Probably maybe 100 yards.
Okay. Did you ask Ms. McCall how much bleach Mr. Tezera threw on her, or how much he or she were using to clean things up in the apartment? Did you ever touch or move any of the bags and other property that was out in the hallway that Appleton and Foster ultimately inventoried?
No, sir.
You mentioned that a knife was recovered from the scene. Was that knife recovered from inside the apartment or somewhere out in the hallway?
It was inside the apartment, close to the couch.
Do you recall whether there was blood on the knife?
I do not.
Do you know if any scales used to weigh drugs, not like to weigh me, were recovered from inside the apartment?
Not inside the apartment from what I'm aware of. It was inside the bag.
A bag being one out in the hallway. Okay. How about large sums of money, significant cash, not $10, but hundreds or thousands of dollars?
I never saw any cash.
Do you know if anyone ever came to APD property to claim the things that were inventoried in the hallway that were designated property as opposed to evidence, like clothes or something like that?
From evidence at the property itself, I don't know their procedures, who collects it afterwards. Once I put it in the locker, I don't know what happens beyond that. But the wallet, the watch, and the belt, I believe, was put at property at Zone 2 precinct. And that is collected by another unit that comes out to all the precincts every night and collected. And it's logged inside a book.
Okay, I didn't ask the question well. We've heard some testimony that evidence that's collected through inventory can be, not evidence, items that are collected through inventory can fall into two categories. Things that are evidence, say it's a gun and there was a shooting. I can't, if I'm someone who was involved with that, I can't come to the police department and say, give me back my gun. I'll be told, nope, that's evidence. But if you also took my shoes and the shoes didn't have anything to do with anything, just you took my shoes, I could go to some place that Atlanta police controls and say, could I please have my shoes back? Because they're designated property and not evidence. What I meant to ask was, do you know in this case, if anyone ever tried to retrieve, not law enforcement, but a private citizen tried to get the property back? Let's say there was a book. I want my book back. Do you know if anyone ever tried to do that?
That I don't know.
Okay. Was there any other information you relied on other than that phone call we heard from between you and Appleton that caused you to say the drugs are connected to Mr. Tezera as opposed to someone else? Because you swore out a warrant, possession with intent to distribute cocaine on Mr. Tezera. Was there anything beyond Appleton saying, hey, in those bags found outside the apartment, we found some drugs?
Miss McCall or Mr. McCall or Mrs. McCall, she stated that those are Mr. Tezera's bags. I asked her whose bags are these in the hallway, and she indicated that it belongs to Mr. Tezera's.
Okay. So you had Appleton saying, in these bags, we found these things, and Ms. McCall saying, and by the way, those bags are Mr. Tezera's.
That's correct. And also, just for the fact that she said that they had an argument, and then in the midst of whatever argument, the beginning, there's a first, second, or third argument that they had. I'm not sure chronologically which happened, but in one of the orders of their fight, she stated that he threw out all his stuff in the hallway, and he grabbed part of his stuff and put it in the hallway as well. Normally, generally, if it's your property at your apartment, you wouldn't throw your stuff out in the hallway. You would just remove the things that didn't belong to you, to the other person, and throw them in the hallway and say, get out. General reason tells me that because the stuff was thrown out, If I was a drug dealer, I wouldn't take my stuff and throw it in the hallway, thousands of dollars worth of drugs. I would hide it. If the police were to come, I would put it in a place where no one would see. They would need to get a warrant in order to retrieve that item. But if it didn't belong to me, I wouldn't want it in my apartment. Get out of my apartment, here's your stuff. So reason tells me as well that it belonged to Mr. Torres.
Okay. You mentioned an officer, or that might not be the right title, Turner. Someone Turner who came to the crime scene from Atlanta Police Department to do some type of work there. Can you remind the jurors who Turner was?
Turner is the ID person, identification. He basically just comes out and takes pictures of the building, the hallway, the door, any evidences like blood stains, knives, or anything of that nature. If it so deems to be fingerprinted, he would do that as well. So he just collects information. That's all ID does. He's basically an investigator, but just on the ID side.
You mentioned that the knife that was found inside the apartment was taken into evidence or was collected. Was there anything else inside the apartment that you recall having been collected?
Just pictures of blood stains, but other than that, I don't recall anything inside the apartment that was collected.
Thank you.
Put into evidence.
Ms. Nix?
No questions.
Mr. Hirsch?
So your testimony is no bags were moved, right, while you were there?
His testimony was about whether he moved any bags, not whether they were moved. The question was, did he move, touch, handle any of the bags?
Right. Did anyone move them as far as you know?
I don't know that. From what I recall, I didn't see the bags being moved.
Okay. You talked about the crime scene, people walking through or not. Was there a witness there, a female with a white t-shirt?
I don't recall a witness.
Okay. At some point, do you recall residents walking down the hall where the blood was?
So I need you to keep in mind, we're focused on the questions that were just asked. We're not reopening cross. Tell me how this connects to something that about which the jurors asked.
I think they asked, did anyone walk through the scene? Did I misremember that?
Yesterday, there was a question asked of
Judge,
a
if
witness.
I'm wrong. I thought that something he said talked about no one walking through the scene.
Well, he was asked, what does it mean to have a secure crime scene? And so if that's what you're exploring, that's fine.
Sorry, Judge.
Okay.
Yes, thank you. You said at a secure crime scene, no one would walk through the hallway at any point once the police get there, right?
Yes.
In fact, once fire gets there, no one would walk either, right?
I don't know how fire does it.
Okay. When you were there, though, you have a specific memory of people walking through the crime scene where the blood is that right? Through the hallway?
No one walked through.
No one walked through, okay.
But let me restate that.
Sure.
There were residents that tried to get to the apartment by trying to walk through the crime area in front of that 256 door, but they were rerouted to go around. So, but there was one particular resident who lived before room or apartment 256 that she could enter that correctly or without disturbing evidence, where she wasn't coming in contact with the bags, if that's what you're asking.
Okay, yeah, did one person walk through?
No.
Okay, so put into evidence yesterday was Officer Skidmore's body cam. I'm just gonna read you the transcript, see if it jogs your memory.
When you say reading a transcript, that makes me nervous. What transcript are you reading?
I'm gonna read my notes from what was on the body cam. I'm gonna tell you what was on the body cam. Tell me if
Whose body cameras?
Officer Skidmore's.
Okay, yes, sir.
Were you there when he told people who were walking through, just keep,
I'm gonna check best evidence that the body cam is in.
Okay, but we could save time if he can just ask the question this way and we'll see what Officer Suk has to say. It is in evidence. We've played it. The jurors have seen what's on there. But if you would rather we play it.
I don't know that it's been established that Officer Suk has seen this footage or if.
Let's just play it. That is cleaner. I know what you're gonna play, and let's have everyone look at it.
Timestamp?
19, let's go to 1920, please. Mr. Suk, I'm just going to play you a little bit from what's already been admitted from State's Exhibit number 13.
Right, starting in 1920.
Yeah, that'd be great.
And this is Skidmore. Yes? I'm not disagreeing with you. Who is it we're watching walk along?
Yeah, maybe I'm the wrong one. Go ahead.
Hey, sir. Just come over here as well. Just watch your step. Just watch your step. Just let it play. Is he getting transported? Yes. Okay. Anything critical life threatening?
Can you pause it, please? Are you on the scene yet?
Not that I recall.
Okay, you saw a person walk through the hallway, correct?
Just now, yes.
All right, you saw a woman with a white t-shirt with a white bag in her hand, correct?
Yes.
All right. And you saw the green medicine, what I'm calling the green medicine bag, where were you there when the green medicine bag was?
The public screen bag?
No, the other one where the prescription pills were found. You weren't there when it was searched?
Not that I know of, yes.
Okay. Do you recall where it was when you left?
No.
Okay. You talked a little bit about Miss McCall. Miss McCall also told you that she took some bags. She said they were hid, but she took some bags and put them in the hallway. Do you recall that?
Yes.
And you talked about, common sense and what if someone who had drugs, whether to put them out. You agree with me that sometimes people who sell drugs are not good decision makers, correct?
Object to speculation.
The question was, did you just say something? He doesn't have to speculate to say, yes, that's what I just said.
Right, he said yes to that, and then I asked, does he agree that, because he was talking about reason what he would think. So I said, do you agree that if he sold drugs, he wouldn't put the bag out? So I said, I'm testing on that. Do you agree sometimes people who sell drugs?
Oh, I misunderstood you. I thought you were still saying, and you said this as well. Okay, so I'll sustain it.
Okay, you gave on direct or redirect, you said what was reasonable for someone to do in Miss McCall's situation, correct?
Yes.
All right, but you also agree it's reasonable if somebody knows the police are coming to not want to have contraband in their apartment, correct?
Object to speculation again.
It's consistent with his previous answer.
You can answer, Officer Suk.
I'm not pretending to know the mind of that person, McCall, of what she was thinking at the time, to whether to put the drugs in hiding or in the hallway. She did put bags out there, but I don't know what her mindset was.
Well, I understand that, but you talked about what a reasonable person in her situation would do when they ask you a question, right?
A reasonable person, meaning just general public, is if you're trying to kick someone out, you generally just try to take all their stuff so they won't come back.
Okay. And generally, let's say generally people who have possession of drugs who know the police are coming try to make sure those drugs aren't found, correct?
Object to speculation.
It's consistent with the same question she asked.
I don't think that was my question.
It wasn't, Officer Suk provided a more expansive answer to a narrower question. I think that's something you're free to argue about what folks would do.
And when you say that this is what someone generally would do, that is what we call an educated guess or speculation, right?
I wouldn't say educated guess. It's just, think that most people would want people based on my experience in domestic, generally when someone tries to kick someone out, they generally want all of that person's stuff out and they don't want him or her to come back.
I understand that, but the question is, if they have contraband, they also don't want the police to find the contraband.
Right, but we're going in circles here, so I'm gonna let you argue that to the jury.
Okay. Thank you, sir.
Officer Suk, appreciate your time. You're free to go. You should take anything you brought and leave everything else there.
Yes, sir, thank you.
You bet. Next witness.
State calls Officer Foster.
Yes, sir.
What is it in the right? You swear affirm that testimony you will give will be the truth, the whole truth, nothing but the truth of God. Swear that I see. David, spell your name for the record.
Can you state your name, spelling it for the record, please?
Officer James Foster, JamesFoster.
Officer Foster, where are you employed?
City of Atlanta Police Department,
What is your position with the City of Atlanta Police Department?
patrol officer.
Are you post-certified?
Yes, sir. Yes, I'm sorry. Yes, ma'am.
How long have you been with the City of Atlanta Police Department?
5 years.
Were you employed in June of 2021?
Yes, ma'am.
And what were your duties at that time?
Patrol officer.
Were you working on June 11th of 2021?
Yes, ma'am.
Did you respond to any calls either that night or in the early mornings of June 12th,
Yes,
2021?
I did.
What was the call that you responded to?
It was an assault call.
What was your role in the response to this call?
To conduct inventory of the items that were there once we got on scene.
What, describe the scene when you arrived.
When we got there, there was multiple bags thrown out in a hallway, and blood. There was a lot of blood.
Where was the blood? Where was the blood?
On the ground, the carpeting in the hallway, and then on multiple items that were thrown out in the hallway.
And tell us what an inventory is.
Basically, it's protocol. We've got to conduct a proper inventory before we submit any type of evidence into property at the Public Safety Annex.
So when you say, you just use the word property and evidence, are they different?
Yeah, they are. I mean, property is property and evidence of both people's belongings, but property is more so like it can be released to pick up once they are able to pick it up. Evidence we're going to keep for proper investigation.
All right, and what is the purpose of doing an inventory?
Just to make sure that the items that we put in the property are safe and they're not going to cause harm to anybody handling them. We just need to verify what it is that we're submitting into property and or evidence.
Okay, and in this case, when you responded to 1888 Emory, it was to do an inventory?
I'm sorry?
When you responded to 1888 Emory, it was to do an inventory?
Yes, ma'am.
What were you expecting to find while you were doing this inventory?
Personal belongings.
What do you mean by personal belongings?
To our understanding, that was somebody who was forced to leave the location, and once we got there, we just saw multiple articles of clothing thrown out in the hallway, and that's what, you know, we assumed that we were inventorying clothing items from that of somebody who was staying that wasn't a permanent residence of the location.
So you're expecting just to find personal items?
Personal items. Yep.
When conducting this inventory, did you find personal items?
We did.
Like what?
Toiletry items, medication, clothing, you know, shoes, shirts, and stuff of that nature.
The clothing, shoes, toiletries, which would you expect them to have been used by a man or a woman?
A man.
And you said some medication that you found.
Yes.
Was it like in pill bottles that you would get?
It was
from
in
the pharmacy?
pill bottles. Yes.
Was there a name on those pill bottles?
I don't recall.
Did you find anything other than the personal items you just described?
We did.
Tell the jury what else you found.
We found 3 bags of items. One bag was a white powdery substance. Another one had a, I don't know, like a green looking type stuff inside of a bag with another brown substance inside of that bag. They were vacuum sealed and they were wrapped in multiple other bags.
And can you give me what's been previously admitted into evidence as State Exhibit 20, 21, and 22? Can you start with State Exhibit 20? Can you look in that bag and tell us what's in there?
Yes, this was a white powdery substance that was found while conducting an inventory in one of the bags. This was actually in a white reusable grocery bag.
Is that the actual substance that you found in when doing your inventory?
Yes, ma'am.
How many of you did 21? You open that and tell us what's in it?
This was another item that was found in that same white grocery bag on that night.
Is that the actual bag that you found?
Oh, yes. Yep.
And Exhibit 22.
Yep, this too was found in that same white grocery bag.
Okay, and that is the item that you found when conducting your inventory?
Yes, ma'am.
Showing you what's been marked as State Exhibit 26. Do you recognize that box?
Yes, ma'am.
Can you tell us how you recognize it?
It was in one of the bags as well. It wasn't in the same bag as the white, or that stuff in the white bag, but it.
Yeah, hold on. You're fine. Please, all lawyers, don't mess with the brown paper bags while the witnesses are talking. They make it real hard for Ms. Rivers to hear what people are saying.
I'm sorry.
It's okay.
Yes, I recognize this box and the content inside the box. This was also found while conducting an inventory on that same night.
Okay, and what's in that box?
Bags, multiple miniature bags.
Were you wearing a body cam while you were conducting the inventory?
Yes, ma'am.
Can you tell us what a body cam is?
A body cam is just to confirm that we're seeing everything that we are actually seeing. Just way to go back in time, I guess, and identify certain items that may be questionable.
And when you are responding to a call or responding to a scene, do you have to turn it on or is it always on?
If we activate the lights in the patrol unit, it automatically turns our camera on. But if not, like to this night, we didn't run code, so the car wouldn't have activated it. So we manually activate our camera when we approach calls like this.
And how is the videos that the body camera records saved?
It's like a cloud, I guess is the best way to describe it. We dock our cameras at the end of every shift, and it's categorized with a body camera specific to that call. So every number is unique, and it's put into a call.
You mean case number?
Case number. Yeah.
I have no objection to foundation and admissibility if the state wants to accept it.
I'm showing you what's been previously marked as State's Exhibit 15. Do you recognize what I just showed you?
Yes, ma'am.
What is it?
It's a disc with video footage of my camera from that night.
How do you know that's what it is?
I'm sorry,
How do you know that's what it is?
because I initialed it, and we verified that through your laptop yesterday.
You reviewed the footage on this disc.
Yes, ma'am.
It is to the State's Exhibit 15.
No objection.
15 is admitted.
I'm gonna get these on first.
All right, I'm showing you what's been previously marked. I think I should do these already, just. These are the screenshots of the file. Right, I'm showing you what's been previously marked as State's Exhibit 16A, 16B, and 16C. Do you recognize those photos?
Yes, ma'am.
What are they?
There are photos of that night of the drugs while we're conducting this inventory.
Are those screenshots from your body cam?
Yes, ma'am.
Do they fairly and accurately reflect what you observed that day?
Yes, ma'am.
Statements to the State's Exhibit 16A, B, and C.
Yes, ma'am.
No objection.
They're admitted. Yes, ma'am.
Oh, permission to publish both 16A, B, and C, and State's Exhibit 15.
Still yes.
Which first?
Do the video.
All right, let's start at the beginning of your inventory. Do you remember which bag that you first looked through? Either you or Officer Appleton?
The first bag that we looked through,
Yes.
want to say it was a duffel bag.
Okay. And what did you find in that duffel bag?
There were bags like those ones along with a scale.
Okay. Are you referring to State's Exhibit?
Yeah, there were a lot of little miniature bags inside of that duffel
Okay,
bag.
is State's Exhibit 26 what was found in that green
Yes,
duffel bag?
yes, ma'am.
You also said that a scale was found?
There was a scale in there.
What kind of scale was it?
I don't know. It was a smaller scale, like
Like, was it,
a digital.
could I get on it
No.
to weigh myself?
No, it was meant to weigh like small items. I mean, not.
You could get on it, no problem. It might not work well.
Kind of walk everyone into that side.
I'm showing you what's been marked as State Exhibit 29. Do you recognize this item?
Yes,
What is it?
scale.
Is this the scale that you found when you were doing the inventory on the early morning hours of June 12th,
Yes.
2021?
Yes, ma'am.
Where was that scale found?
It was in the duffel bag.
We're gonna show State's Exhibit 15, starting at 1544. Alright, why are you dictating what you're finding?
I'm sorry,
Why are you dictating what you're finding?
dictating what I'm finding.
No, why are you telling Appleton?
Oh, he has to, so the proper way to do it is for one officer to do a proper inventory, while the other officer writes down what me being this officer is finding. It just makes it a lot easier than going back and forth from the notebook to the items that we're trying to put in the property.
Okay, and I think that you were pulling that box that says Exhibit 26 out of the bag when we first started the video, is that right?
Yes, ma'am.
So the top put, Emmanuel Tezera. That,
Right, the name that you just read out, is that what was written on that pill bottle?
Yes, ma'am.
You just took that out of the same bag that you found the baggies and the scale in?
Yes, ma'am.
All right, now we see you open up the pill bottle, why did you do that?
Just to count how many pills are in there and make sure they all look the same.
Okay, is that standard protocol in doing an inventory?
It is.
Let's move on. So after you, oh, sorry, I ended at 1720. So after you searched or inventoried, excuse me, the green duffel bag, what did you do after that?
Just went down the line. That was the first bag that I was able to see, so I searched that one first and eventually conducted an inventory and then just worked down the hallway to the rest of the items.
Okay, so we've moved your body cam to timestamp 2102. What do you see you inventorying right here?
Is it another? It's another bag.
Those the other items that were in the hallway?
The other items, yes. Yeah.
Okay, so those other pills that you found, did they belong to the same person as the other pills?
I can't recall.
You and Officer Appleton kind of discussed where you should put them. What are y'all talking about there?
Back where we found them.
But the pills that were found in that backpack that you're looking through right now,
Right.
did y'all talk about putting them with the other pills?
I just put them back in the same bag that
Okay.
that I found them in.
I just looked at what your items. So you got multiple bottles of one.
Okay, that white bag that you just took out of the blue toilet tote, is that the bag that you eventually found these items in that were admitted as exhibits 20 through 22?
I believe those ones were in the white.
Yes, the white bag.
The Publix bag.
The white bag that you
green-
just took out of the blue tote.
That was one of them, but there's, I think the majority were in the green Publix bag. Right.
Earlier you had said that you found these items in a white tote,
Bag.
grocery bag?
Right, yes.
Okay, so is that the reusable grocery bag that you just took out of the blue tote?
Yes.
Okay. Okay, and then now we'll skip forward and your body came to when you're actually searching that white tote,
So we ended it.
so we ended at 2309. We'll just skip forward just a couple minutes. During this time, are you searching what's in that blue tote?
Sorry.
During this time, where we're gonna skip the video, are you just searching through that blue tote?
Yeah, those were basically just articles of clothing and toiletries.
Okay. Right, now we're gonna start the video again at 2600. All right, what is this red substance that we can see on the back?
It looked like blood.
We got everybody.
Pause at 2641. Show you what's been marked as State's Exhibit 22. Is this the same item that you see in your writing that you found in that white bag?
Yes.
Sir. Sir. So this is.
Can you hold up that box so I can see it? Okay, I just want to see that it looks, see how it looked like that one. Okay.
Oh, hell. Yo.
I'm showing you what's been marked as State Exhibit 21. Is this what we see in your body cam that you found in that white bag?
Yes.
This is the same package, same substance, everything the same?
Sir.
Showing what's been previously admitted into evidence as 16B. This is a screenshot of that bag that you're just opening here in your body cam now.
Yes, ma'am.
What do you see in the top little, can't see it in body cam?
Oh, blood. That's blood. I mean, it looks like it's blood.
Yes, sir.
Showing you what's been marked as State Exhibit 20.
Yes, ma'am.
Is this the bag that we just saw you recover? Now, in this bag, there appears to be new test tubes. Were those in there when you found the drugs?
I remember, yes.
So if these were added by, you see writing on them,
Yes, ma'am.
were those added by the GDI?
Objection, lack of personal knowledge. He's already testified they were in there before they got to the GBI.
So you need to ask your question in a different way.
The writing on it, is that a what are the initials that are written on it?
S-A-H.
SAH?
S-A-H.
All right, now in are these the actual drugs that or substance that you found?
That's a
in it?
substance that was in that bag.
Okay, now, I had asked you a second ago about some test tubes. Are those in your body cam?
No.
Okay. So now that you're looking at your body cam, does it refresh your memory whether those,
It
those
does.
test tubes were in there when you found it?
I don't believe that they were in there after.
All right, now what we just heard you say was, let's go get the scales. When you and Officer Appleton found the baggies and the scale, was that illegal? Was that a substance or a item that you would find to be contraband?
I would consider it illegal if there was no substance around it.
Okay, but later on, when you found the substance, did those items become more significant?
Yes, ma'am.
Why is that?
Now it's, you have intent to sell. I mean, you've got, appears to be a powdery substance that possibly be illegal, and now you have a scale and multiple baggies. It brings it to a whole different ballgame.
Have you been involved in drug investigations as a part of your employment with APD?
No, ma'am.
In your training and experience as a law enforcement officer, are the presence of baggies along with a large amount of substance, like white powdery substance, is that indicative of something based on your training and
Yes, ma'am.
experience? Okay, tell us about what is it indicative of?
Distribution of an illegal substance.
All right, so I'm showing you what's been marked as, into evidence as State's Exhibit 16A, B, and C. And we already talked about those are screenshots from your body cam. Drawing your attention to 16A, specifically what is depicted in that photo?
This first one. Yeah, it's the bag that contained those substances, covered in blood. Or
Okay.
what looks like blood.
Okay, and where is the majority of the blood on this bag?
On the outside of it.
Is it on the handles?
It's all over the handle and the outermost part of the bag.
Okay, now let's look at 16B. What is depicted in this photo?
There's one drop of what appears to be blood.
And what is that white plastic bag?
That's one of the bags that had some of the substance in it.
And you said that there's a red drop on it,
Yes, ma'am.
and it appeared to you to be blood.
Yes, ma'am.
And 16C,
It's another bag containing some of the substance.
okay, and is that what you believe to be cocaine?
Yes, ma'am.
Tell us about the difference between property and evidence.
I said before, property is stuff that's turned in and it's able to be picked up by the individual. Whereas evidence is something that we kind of need to help support whatever we originally went to the call for, and we can't pick it up.
Okay, so you find a lot of things during this inventory. You said clothes, toiletries, shoes. How are those classified as property or as evidence?
That's going to be property.
And then these drugs that you found,
That's
how are
gonna-
they going to be classified?
That'll be more evidence,
Okay.
just so we can be able to identify, what exactly they are.
Okay. Did that conclude your involvement in this case, or did you do anything else?
I relieved Officer Philemon at Grady once the individual got transported there. And once that individual was cleared, I dropped him off at Fulton County Jail.
Okay. Do you see the individual that you met at the hospital and then took to Fulton County Jail in the courtroom today?
Yeah.
Can you point him out for the jury? And describe what he's wearing?
The blue suit.
Can you be more specific?
Blue suit, blue tie, short hair.
Does the record reflect that the officer has identified the defendant?
He has?
And, when you, transported him, did you bring any medication or drugs with him?
Grady supplied him some medication to bring to jail. And that's the only medication.
Was it your job to do any investigation in this case?
I wasn't the primary officer, so no, it was just inventory. That's basically all I did.
Was it your job to direct anyone to get any fingerprints?
No.
Nothing further, subject to redirect.
Mr. Hirsch? I don't want you to be surprised. In about 15 minutes, we got to stop for lunch. So you'll be able to continue after lunch if you're not done. I'm not cutting you off. I'll just be pausing you.
Thank you, Judge. I'll be done. Good afternoon.
You know,
Good. How are you?
good, thank you.
All right. So when you got there, you guys didn't move any bags, right? All right. So I'm going to call the bag where most of his not his backpack, but there's a green bag where his medication is found, right?
The duffel bag.
Okay.
Yeah.
Call it the green duffel bag.
Okay.
All right. I'm going to call it his medicine bag because that's what I've been calling it. That medicine bag is not with the other bag. It's down the hall a little bit, correct?
Right.
All right. And it was Officer Appleton that was going through that.
The medication bag?
Yes.
No, I was inventorying it and he was writing the items that were in the bag down on a piece of paper.
That's when you're looking through his backpack, correct?
The duffel bag.
All right.
So, I'm sorry.
That's all right. Let's be clear. And if I'm not, let's see.
The very first bag that had the majority of the medications.
Okay, go ahead.
Yeah, I was, Appleton was just writing down what I was finding.
Okay, so going through the green bag, you're the one who went through it, not Appleton.
Yes, sir.
And Appleton was simply writing down what prescription drugs you were pulling out of the side pocket of the bag, correct? All right, and there were about 7 or 8 bottles of medication, right?
I don't know an exact number, but approximately.
Okay. And none of you actually moved that green medicine bag down the hall. That's where it was the whole time that you were there, correct?
Yes, while I was there, yes.
All right. Now, in addition to that, you go through his backpack, the multicolored backpack, right?
Yes, sir.
And you find 3 additional prescription pill bottles in that backpack, correct? All right. And those prescription pill bottles, of course, you don't put that somewhere else. You put it right back in the backpack, right?
Yes, sir.
Like you would never take that medication, walk down 25 feet down the hall and put it in the green medicine bag, right? Okay. And you didn't do that in this case. You're able to ascertain that, you know, he had epilepsy and had seizures.
I don't know his medical condition.
Okay, but you saw the medicine, you were accurate, you know, medicine they gave him.
Yeah, I don't know what it was. I can't pronounce the medication name, let alone what it's for.
You heard the word seizure at the hospital, right?
I can't recall.
Okay. So you talked about the blood in the bags. Now inside the white coat bag is a white pillowcase, right? That has a little bit of blood on it, right? And then you have these individual smaller bags, and inside each of those bags, we have the 3 different substances, right? Oh, you have to say yes or no.
Yes.
Okay.
Yeah.
All right. So there looks like a cereal box is one.
Yep.
Okay. And then there's what looks like maybe some chips, some sort of snack, plastic cellophane bag.
Yes.
Okay. And then the white powdery substance is found inside of 2 red bags, right?
Yes, sir.
Okay. I'm gonna hand you what I've marked as defense exhibit number 26.
Yep.
You recognize that?
I did.
I move to admit defendants 26 into evidence.
So two things. One, Ms. Nix, do you have any objection to defense 26? I don't know if you've seen it.
It is, I believe, just a screenshot of the body cam, which we've already seen.
I don't, it's a picture of a red bag.
Oh, no objection.
Okay, 26 is admitted. But I'm confused before we go further with that. You found three different sets of potential drugs. One is in ultimately a Cinnamon Toast Crunch box, which is inside all these different red bag. What was in the Cinnamon Toast, the cocaine, or was that the, I could have sworn the cocaine comes out of a white bag where you're just untying some knot.
So there were the multiple bag, but they all, when it come down to the actual substance, it was inside of a clear plastic.
True, in the end, when you're holding something up, they're always a clear bag because you're able to see it. Green leafy, whatever those brown things were, white powdery substance. Okay, I mean, your video is going to show what it is. I'm just confused by the questions, but that's me. 26 is in.
Thank you. One of the substances came out of this red bag, correct?
Yes, sir.
All right, and there's writing on that bag, right?
There's what in the bag?
There's writing on the bag?
Yes,
All right, did you go through the apartment at any point?
just to secure the door once we left.
Right, because you guys didn't have a key, right?
That's correct.
So you go inside the apartment, you lock it from the inside, right?
Yes, sir.
And then you have to go out the back, out her patio or something.
Yes, sir.
While doing that, did you inventory the apartment at all?
No, I didn't.
Did you go into her bedroom?
No, I didn't.
That LV on that bag, is that the symbol for Louis Vuitton?
Yeah, I'm not, yes. I'm not familiar.
You're not a Louis Vuitton
I know
guy?
Louis Vuitton, I don't, yeah.
All right, thank you, nothing.
Yeah.
Any redirect?
So we watched your body cam and the items that were in the red bag, was that the suspected mushrooms and marijuana?
I believe so, yes.
Okay, and then, so you found those things first and second, and then you move on to another white grocery bag.
Yep,
And what was in that bag?
that was the Cinnamon Toast Crunch box with the white powdery substance inside of that.
Okay, thank you, no further.
Nothing? Jurors? Questions for Officer Foster? None? All right. Thank you, sir. Appreciate your time. You just leave everything right where it was unless you brought something, then you take that with you. Your water, you keep it. Ms. Nix, next witness.
Your Honor, the state rests.
Well, that's good timing because it's about time for lunch. Ladies and gentlemen, we're going to take a lunch break now. I'm going to ask you all to be back by 1:30. At that point, I will ask Mr. Hirsch if he's going to be presenting any evidence. I'm going to remind you, you heard me say it before, there's no burden on the defense. So Mr. Hirsch may say, Judge, we rest. But the defendant has an absolute right to call witnesses and the ability to do so. So Mr. Hirsch may call 10 witnesses, one witness, whatever they're going to do. I'll talk about that with them over the course of lunch. But that's what we'll do when you get back, is see if there's anything from the defense. If there's not, evidence is closed, and we will move into the summations or closing arguments where the lawyers argue to you what the evidence has proven or failed to prove. And I'll give you a jury charge and we'll go from there. All right? Any logistical questions? Don't talk about the case. Even though the state has rested, there's more to come to include the law that I have to give you. So no outside research. Enjoy lunch, and we'll see you in about an hour.
All right, good.
All right, you all can be seated. We've got about 5 minutes before we need to break. Mr. Hirsch, do you have a motion to make at this time?
Yes, sir, I'll make a motion for directed verdict.
All right,
You know, I'm used to when these are effective, there's usually a technicality, they forget venue or something like that, or they forget an element. That's not the case here. The standard is, they're going out that way?
they're not coming through this door.
Okay. I keep looking over.
That's okay.
Can any reasonable jury, this is a sufficiency of the evidence, can any reasonable jury find my client guilty beyond a reasonable doubt? And although the evidence came in as to the crime lab, that in and of itself, there are so many mistakes. That the chain of custody, although usually it goes to the weight, not the admissibility it is in, but then based upon cross, everything they say they did seems just to be wrong. The crime lab says, you know, procedures to put initials on. The police say we don't have to put initials on. Yet there are initials on there, both two sets, one from the crime lab, one from an unknown person.
So I don't want to prevent you from making the full argument you want to make, but you know the standard as well as I do, which is that if I have to view the evidence in the light most favorable to the non-movement. So if all the credibility issues and the conflicts of the evidence were resolved in favor of the state, would it still be not possible for a reasonable juror to find your client guilty? And that's not correct.
Right.
A reasonable juror could say, whoop, look at that. We've got two boxes that match. One's in a bag that has his pharmaceuticals in it and no apparent women's underwear or women's bathing suit bottom if it's not a tidy male pair of underpants. So there are things that connect it. Is it messy? Is it sloppy? Have you punched 5,000 holes in it? Sure. Is there reasonable doubt? Maybe so. Not the standard. So I don't disagree with anything you said and what I suspect you will be saying. But if you think there is a magic bullet that has come through here that makes it improper for me to let the jury weigh this, the good, the bad, and the ugly that they've heard so far. I don't mean to preclude that, but you were starting to make an effective closing. Don't want you to preview all that for the state. But I don't think, having heard all the same evidence, conflicts in the evidence and lack of evidence you've heard, that it moves the needle to that very, very extreme. It's like you said, it's usually a technicality. No one said Fulton County.
Right.
We had that dispatcher saying, oh, it's a DeKalb address. That's been cleaned up. Several witnesses at Fulton. And it's not that the indictment charged cocaine and the crime lab said it's a whole lot of meth. Well, they said it's cocaine. So I don't think it rises to that level, but I want you to make the record you should make.
The last statement I'll say is I thought the standard was 4,999 holes and I've done 5,000, but I'll submit on the evidence.
All right. Thank you. Ms. Nix, you don't need to respond. I think that you're aware that there are challenges with the 3-year-old drug case where there's no lead investigator. And so lots of things get left unaddressed. You and Mr. Peoples will handle those in your closings when it's time. But I do think that there is evidence by which a reasonable juror could find Mr. Tezera as the person who possessed drugs a substance that tested positive for cocaine, more than 200 grams, purity greater than 10%. I don't know that that's what the jury will do, but if they did, I would not be entertaining a 13th juror situation. I would understand how they got there. So we'll see what happens between now and then. So I'm denying the motion for directed verdict. This ought to stay with the jury. This is why we have juries. I also see why we don't have a plea in this case. And it's been well lawyered on both sides so far. Mr. Tezera, over lunch, you can have your final round of conversation with your lawyer, with friends and family about whether you're going to testify. When we get back at 1:30, I'm going to have that conversation with you, jurors not in the courtroom, lawyer by your side, about whether you want to testify and the consequences of choosing to testify, and the protections you have if you choose not to testify. Will you be ready for that conversation?
Yes.
Great.
Your Honor, you may want to do it that way as a courtesy. He's ready to answer that question now, if the court wants to have that conversation now.
Great. Let's do it now and allow everyone to prepare. Okay. Mr. Tezera, let me make sure I cover this carefully. Do you understand that you have a right to testify and that if you want to testify, no one can prevent you from doing so? Your lawyer cannot overrule you. Do you understand that? Do you understand that in the same way, no one can compel or force you to testify? Meaning if you do not want to talk about this case under oath to this jury, no one's going to push you up there. Your lawyer can't twist your arm, and certainly the state cannot call you as a witness. Do you understand that? Do you understand that in just a moment, I'm going to be asking you and not Mr. Hirsch if you want to testify? Do you understand that if you choose not to testify, I will instruct the jury that they should draw no conclusion or inference hurtful or harmful to you in any way, that they are to disregard the fact that you did not testify? Do you understand that if you choose to testify, it will start with Mr. Hirsch asking you what I'm going to call the easier questions, telling your side of the story. You will also have to answer every legally proper question that a prosecutor asks you on cross-examination. You don't get to take the fifth. You don't get to say, nope, I'm done. I've answered my lawyer's questions and I don't want to talk anymore. Do you understand that? And that applies to the jurors' questions as well. If a juror asks a legally permissible question, you'll need to answer that question. You understand? Okay. Mr. Tezera, do you wish to testify in your case? All right. I find that Mr. Tezera has made his decision not to testify with a complete understanding of his rights. I also find that he has been well counseled by his attorney about those rights, but that Mr. Tezera has independently and intelligently made the decision not to testify. I will give the appropriate charge to the jury that protects his rights in that space. Mr. Hirsch, do you plan on calling other witnesses? At this point, you have an hour to think about it.
Private motion, so it depends on what happens with that motion.
Okay.
Your Honor, of course, I'm entitled to any Brady information, even if it comes up during trial. And I haven't asked the state this before, but Ms. Cameron McCall testified that she had on her phone other ring videos and stuff. And then I'm presuming the state then had a new, after she got off the stand, had a new conversation with her and said, oh, can we see those? Are those available? If the answer was no, if they didn't have the conversation, fine. If the answer was no.
So you haven't asked the state yet what happened after her testimony?
Correct.
Okay.
But if the answer was no, then it's Brady material. I feel like they'd be obligated to tell me that no, there was no further ring camera. So I'm asking if that did happen for them to disclose it.
Okay. So sort of a motion. I guess it's something you could have done during the break to see what they tell you, and then you might have something that needs to involve me, which is how I'm going to handle this one. Why don't you speak with Ms. Nix and Mr. Peoples, and based on the answer you get, we'll revisit that at 1:30. Also at 1:30, we'll do one last run through the jury charge to see what, if anything, has changed. My question, though, was, are you planning on calling anyone else? I guess partly it depends on the answer you get, although I don't see Ms. McCall anywhere, so I don't know how you get her on the stand.
But be an investigator.
Okay, got it. So you have an investigator at the ready, and that is contingent upon an investigator, as in your investigator or law enforcement?
If they had a conversation, if investigator A said, hey, can I see your camera? And she said, no, there's nothing on it. Or if investigator A took the phone and there was nothing on it, I'd call their investigator.
Got it. A Fulton County DA investigator.
Yes.
Got it. Okay. But that would be it.
Yes.
In terms of your witnesses.
Correct.
All right. Then you all should be ready to go with closings. Ms. Nix, Mr. Peoples, do you plan on opening and closing?
Yes, sir.
Okay. So your 1 hour will be broken up however you break it up. And we will take stock of the jury charge and of the ring camera video situation upon return from lunch. Thank you all. And I will mute things here.
We should try.
Is that Ms. Rivers, are you ready to get on the record?
Yes.
All right, we are back on the record in State versus Tezera. We finished our lunch break on Thursday. And Mr. Hirsch, before we broke, you were going to engage the state on a topic. Did you have the conversation you needed to have, and do we need to talk about that anymore?
Yes. Well,
Because I asked you two questions, so
Yeah.
yes isn't clear
I
answer,
had
my bad.
Conversation, I just found out this information, and my understanding is Investigator Dickerson, who's present, interacted with Ms. McCall, and they weren't able to find any information on her phone. So that's the information I've been given.
Okay,
So I will call Investigator Dickerson for that purpose. I'm not asking for any hearsay. I'm just asking to,
so it would be to explore, did you interact with Ms. McCall, and as a result of that, were you able to obtain any Ring camera footage
Yeah.
from her cell phone?
did you or she try and get any Ring camera footage or any other footage, correct?
And is your understanding that Ms. McCall said, sure, let's try, no, you can't? What,
That I don't know.
okay, Ms. Nix, what do we know?
I think we can stipulate, I don't think that Investigator Dickerson needs to testify that she, as part of her duties, did sit with Ms. McCall as one of the state's witnesses, and that they did, I guess, discuss these videos, but that Ms. McCall was not able to pull them up on her phone. That's kind of the extent that I know as well, but I don't think that we need to get into anything further. This is not evidence that was held by the state.
Mr. Hirsch isn't saying that's what happened. He's entitled to get that. Ms. McCall said on the stand, if I recall correctly, oh, there's more, and it's on my phone. And Mr. Hirsch said, great, where's your phone? Or where is that kind of stuff? So I think it's an appropriate topic. If he's okay with the stipulation, I can tell the jury, and we'll work on the words, but it wouldn't be an abuse of witness examination to have Hirsch call Dickerson to answer those questions, just on that topic. So I'm not going to force him to agree to a stipulation if he'd prefer to have it come from a witness, but that's not.
I think that there's a threshold that we've not met, which is whether this is exculpatory. And from Ms. McCall's testimony, it sounds like it would not be exculpatory.
So it would directly impeach what she said, unless I'm misremembering. She said, there's more and it's on my phone. And yet when Investigator Dickerson met with Ms. McCall, let's look at your phone, there wasn't more Ring camera footage on the phone. So that impeaches Ms. McCall, which is certainly advantageous to the defense. Does it exculpate directly? No, but it calls into question the veracity of a witness who says the drugs were not mine, they were Tezera. So it's pretty much in the heartland of what the defense can get into. Now, I'm gonna let you two talk for a second about whether it's a stipulation or Mr. Hirsch wants to call Investigator Dickerson, but it's relevant. I'm making no finding, nor do I even have an inkling that the state's done anything wrong here or that they withheld anything. I think everyone was surprised to hear Ms. McCall say, I got hours of Ring footage on my phone. But it sounds like that was mistaken at best, untrue at worst. I won't say any of those words to the jury, but how could the defense not explore that if they wanted to? And they can do it in one of two ways. It can be a stipulation if the defense wants to do that, or they call Investigator Dickerson in that super narrow area. I'll cabinet if he gets away from, did you interact with her after her testimony? And he'll ask the questions in a better way. Did she have that? Was that on her phone? We were unable to get that from the phone. Okay. But I don't see how he's not entitled to do that. I don't mean to make your argument for you.
Right.
So anything else you want to get on the record about that?
We just maintain our objection, but understand your ruling.
Okay. Mr. Hirsch, do you want to call the witness or have me tell the jury the parties stipulate that basically the following happened?
I think I'll call her.
Okay. Will you be calling any other witnesses?
No.
All right, and then you're resting.
Yes.
All right, are you planning on calling any rebuttal if we're limited to Investigator Dickerson talking about that one topic?
Yes, sir.
Okay, are you, one last thing, we gotta, do the charge. Let me share screen. So we'll take judicial notice out. I will give defendant's choice not to testify. Limiting instructions and prior difficulties still out. Character of the defendant is out. Parties to a crime is out. Weight is out. Over objections. I don't think there's anything that changes from what we discussed before. Mr. Peoples, was there anything you thought of to add or subtract since our last discussion?
No, Your Honor.
Okay. I know, Mr. Hirsch, you were hunting around for this extinct jury charge about, I don't even remember what it was called, two theories. Yeah.
It's subsumed in the circumstantial evidence charge now.
That's the advice I got as well. So we're covering it. Okay. Anything else on the charge?
No, sir.
Okay.
Character of the defendant, you said is out.
Is out. And I will give you, you'll get a hard copy of what the jury's going to get. I'll be massaging that during the closings and we'll get that to you all. Okay. Ms. Nix, you ready for the jury?
Do we want to address the GBI report? One more thing, Judge, just to get some clarification on the GBI report was admitted into evidence. At the time that Summer Hutton was testifying, it was not published to the jury. I think just because of the issues with the custody and who it was that actually found the drugs, because we had to take her slightly out of order. And so I wanted to make sure that we were good in putting it in our PowerPoint when closing.
Okay. Your thoughts about the GBI reports, Mr. Hirsch?
I think they can publish it.
Okay.
Okay, thank you, Judge.
There you go. Anything else?
Nothing else from the state.
Okay. Mr. Hirsch, anything else?
No, I'm just not seeing it. I'm just looking for the charge
Well,
on the defendant not testifying.
it's on the, I'll put it back on the screen if you want to see it.
Okay, page 4. Okay.
Yeah. It's the pattern. I mean, it might be slightly altered because I'm a big fan of plain language instructions, but it is the essence of the pattern. Okay. Unfortunately, I don't know Investigator Dickerson. Is she nearby to testify? More than nearby, right there. Excellent. Stay right there. Let's bring the jury in, please.
All right, so jurors. All jurors are present and accounted for.
Thank you, Deputy Gordon. Everyone can be seated. We're almost done, so I should have said this earlier. You don't have to remain standing when you come in. We stand for you, you sit, and then we sit, but everyone's respecting everyone, so thank you. It's a respectful group. When we broke for lunch, the state had rested. That triggers a couple of legal things that need to happen. We took care of that during your lunch break. And it is now time for me to ask Mr. Hirsch if he will be calling any witnesses.
Yes, Your Honor, the defense, may I do so now?
You may.
The defense calls Investigator Dickerson.
Investigator Dickerson, if you'd come up, please.
You swear affirm that testimony you will give the truth, the whole truth, nothing but the truth, so help you God. State spelling name for the record.
I'm Investigator Amina Dickerson, AMINAH. Last name is Dickerson, DICKERSON.
Good afternoon, Investigator Dickerson. Can you let the jury know who you work for?
I am a senior investigator for Fulton County District Attorney's Office.
How long have you done that?
I have been here for a year.
And prior to that?
I was at Fulton County Solicitor's Office, and I was there for a year.
All right. And before that?
I was a DeKalb County Marshal for 3 years, and I was a DeKalb County Deputy Sheriff for 7.
Okay. So that is 13 years in law enforcement?
Yes, and then I was also a jailer at DeKalb County, so that was also for 7.
All right, go ahead.
7 years there too.
Are you post-certified?
I am.
All right, that means you went to the police academy and you're a police officer, right?
Correct.
All right. Are you the Fulton County DA's investigator on this case, State versus Emmanuel Tezera? Or
Yes.
at least one of them?
Yes.
All right. So you're familiar with the case?
Correct. I am.
All right. Okay. On Tuesday, Ms. McCall testified. Are you aware of that?
Yes.
All right. When she got off the stand, did you have an opportunity to do any further investigation with her?
When she got off the stand, no.
Before she got on the stand, did you do any investigation with her?
Before she got on the stand, I had to pick her up from the airport. So when we got to my office, we had to wait for her chance to come to the courtroom. And she meant, okay, that's,
all right.
I was able to speak to her again.
Regardless of how it happened or who said it, did you and she look on her phone for Ring camera video?
No, she mentioned that she had Ring camera footage. She tried to pull it up, was able to pull it up on her phone, but she was only holding it. She never showed the video to me. She was just talking about it. So you were able to hear like footsteps or something. She said she would send it, but it wouldn't send because it said it was too big, too large.
Okay, and so you never looked at this video?
I never looked at it.
And it was one video?
I don't know how many videos it was. I just heard feet running when she pulled it up. That's all you could hear, because in my office it's set up where we're not sitting beside each other.
All right. So did you, to memorialize this, did you just take a video recorder and record whatever video she had?
No, I didn't.
All right. So she told you she had hours of video and you didn't record any of it or receive it?
I did not.
All right.
I couldn't receive it because she said it was too big.
All right. But you have the ability to record something that is playing, right?
If I did it from like my phone, but I didn't.
Okay. After she testified and this came out on the stand, did you or anyone else engage Ms. McCall about getting the videos, which she had not yet sent you?
No.
Thank you.
Ms. Nix or Mr. Peoples, any questions for Investigator Dickerson?
Investigator Dickerson, what was your role in this case?
So I gather information needed from the attorney. I serve subpoenas for the case. I pick up the witness or the victims for the case and assist the attorney with whatever she needs. Beside that,
Were you involved in the original investigation of this case?
no, I was not.
What did you do after Ms. McCall testified?
I took her right back to the airport. So we left here, got in my truck, and I drove her to the airport.
You said on direct that Ms. McCall did not send you the videos that she discussed?
Correct. She never sent them.
Did she tell you why?
She told,
Your Honor, hearsay.
This is something you already covered? You can answer the question.
Oh, okay.
she told me that it was too large to send from her phone, so I never received it.
Do you know or do you have any training in IT?
I do not know.
Nothing further.
Any redirect?
No, Judge.
Any questions from the jurors for Investigator Dickerson? See no one reach for a card. Thank you, ma'am, for your time.
Mhm.
Mr. Hirsch, next witness.
Defense rests.
Any rebuttal, Ms. Nix?
No, sir.
All right, ladies and gentlemen, the evidence in this case is closed. You have seen and heard and received in terms of exhibits, everything you're going to get. Two things remain. One has two parts. Next up is the closing arguments or summations from each side. Both sides are entitled to come before you like they did at the beginning, but now to truly advocate, to attempt to persuade you to decide the case in one direction or the other. Reminder, what the lawyers say is not evidence. If a lawyer tells you witness X said that the sky was falling that day, and that is not how you remember it, you shouldn't say, well, wait, the lawyer said that was the case. It's your recollection. It's what the testimony was. It's what's in the exhibits. But it's perfectly appropriate for the lawyers to advocate and attempt to persuade you. Because the state has the burden of proof, they get to go first and last. Both sides get the same amount of time, but one of the prosecutors will get up and give you an initial sense of the closing argument. Then if Mr. Hirsch wants to give a closing, doesn't have to, no burden on the defense, but I bet he will. When he's done, then the state has the remainder of its time to rebut or say what they want after Mr. Hirsch has spoken his piece. When that's done, we'll probably take a break, but right away or right after the break, I will then give you the law, the charge that you must apply to the evidence you've received. Once that's happened, it's back to the jury room. All these exhibits go with you. You can review the videos if you want on the screen that's in there, and you will begin your deliberations. Okay? Ms. Nix or Mr. Peoples?
Share it on Zoom.
Yeah, I got an awesome.
While that's preparing to come up, good afternoon, ladies and gentlemen of the jury. Thank you so much for your patience. Thank you for sitting with us through our technical difficulties and all the other issues. Again, as the judge just informed, myself and then 88 Nix will explain to you and our position on this case. I'll speak to you specifically about some of the law, but the judge will give you the specific instructions, and then 88 Nix will follow me, and she will give a more thorough explanation. So I see that you have your pens and pencils and paper. I ask that you take notes, take your time, listen and listen, okay? My name is Attorney Peoples, and I'm here on behalf of the state of Georgia. Ladies and gentlemen, you as a juror have a duty to be fair and impartial and honestly seeking the truth. Not seeking doubt, not seeking anything else, seeking the truth. Again, you're not to be seeking doubt, and you're not to go looking for it. There are certain things that you can consider in seeking the truth. Those can be the statements that you've heard. Those can be the expert testimony, which we heard from an expert here, Ms. Summer Hutton. The testimony of any victims in some cases, photos or documents. You've been shown plenty of photos. You've been shown some documents. You can also use your common sense. My grandmother used to say common sense, the least common thing in common people. But I know that everyone here has common sense. You can rely on the testimony of the witnesses, and you can also look at the elements of a crime and any motivations to lie. Now, as you look at all of these things inside the circle of consideration, I want you to also think about the things that are outside. Don't look to those. Those are not to be considered. Don't think about your passions. Don't think about any public opinion. That you are unhappy with any law enforcement, any public feelings, sympathy for the defendant, as the judge will instruct you on the law. Think of those things, any prejudices that you may have, any disagreements that you may have with the law, and you are not to concern yourself with any punishment or any penalties. Merely inside that circle of contemplation are those things right there. The statements that you've heard, the photos, the documents, the testimony. Several people have come before you this week and given you extensive testimony, the testimony of Summer Hutton, the expert witness from the Georgia Bureau of Investigations, the GBI, who did the testing. Several law enforcement officers. You heard from Cameron McCall. Look to those statements that they provided, the testimony of those witnesses. It's important. Again, I ask you to write it down because it is important. And I've seen you doing so this entire week. You have a duty to follow the law. You're bound by, excuse me, by the instructions and the law that will be given to you by the judge at the close of this process. Listen closely, write it down, they'll give it to you, but write it down, remember. Each of you has a duty to deliberate. However, you also have a duty that if there is one among you who refuses to do so, that you have a duty to bring it to the attention of the court. There are a few legal principles here. Again, the court and the judge will instruct you on the law, but there's a couple things that we want to sort of tighten for you. The burden of proof rests with the state. And with that burden of proof comes the responsibility that we must prove beyond a reasonable doubt every element of the crime. And we'll address those elements soon. But we must prove it beyond a reasonable doubt. That's the standard. Not beyond a 100% certainty, a reasonable doubt. That is the standard, that is the state's burden. I believe that you will find that we have done so. Now, the defendant enjoys the legal presumption of innocence until the state proves, again, that magic phrase, beyond a reasonable doubt. This doesn't mean he's actually innocent. Now, think of it this way. The presumption of innocence works like a nice cloak. I know people don't wear those much anymore. However, think of it that way. The presumption of innocence is a defendant walks into this courtroom and is covered in innocence, which is the law. As you hear each of these witnesses come to testify, maybe a shoulder comes off. Maybe the other shoulder, maybe the hood. You start to untie it until finally that cloak falls to the floor. Again, you heard testimony from several witnesses that we have presented to you this week. You heard from Cameron McCall, you heard from Summer Hutton, you heard from several law enforcement officers, Officer Suk, Investigator Skidmore, Officer Philemon, and each of those witnesses came before you today and worked to take off that cloak. And once it's been done so, we look to say that the guilt has been proven. Now, we talked about that magical phrase. Not magical, important phrase. Reasonable doubt. That's what it says, reasonable. It's based upon, as I said earlier, use your common sense. Reasonable means the common sense, not some vague, amorphous, unreasonable, or arbitrary. Reasonable doubt. We're not required to prove beyond a mathematical certainty, not to 100%. Reasonable doubt. And that means doubt for which reason can be given. And that reasonable doubt has to be based upon the evidence that was presented to you. Again, we've been here nearly a week, and several pieces of evidence have been presented to you. Several documents, several photos, several videos, and most importantly, the testimony of several witnesses. Take all of that into account. Again, as we stick to this point of reasonable doubt. Former teacher. And I like to drive it home. Okay? Unreasonable and reasonable. All right? Unreasonable means non-existent or unpresented evidence. You can make something up in your head and say, well, you know, what about that part? That wasn't presented to you. Not mere conjecture or speculation, but reasonable doubt. Common sense. Again, not vague or arbitrary. Common sense, which means the doubt for which, again, excuse me, reasonable doubt, which means the doubt for which a reason can be given. You're not to concern yourself with any punishments or penalties, as we discussed a couple slides ago. You're bound by the instructions and the law that will be given to you by the judge, by the court. That's the only thing. That, as well as the evidence that has been submitted to you for consideration. Now, there's types of evidence for you to consider. Direct evidence. Which can include the testimony of the witnesses, what they saw, what they heard, what they felt, what you've heard this week. You heard extensive testimony from Cameron McCall about what she saw, what she felt, what she heard. You heard extensive testimony from the officers about what they saw and what they heard. Additionally, look to those tangible items, photographs, which there are many, videos, which there are quite a few, and any documents. Look to those things. Remember them, write them down, refer to your notes. But most of all, remember to use that all-important common sense. Now, we talked about direct evidence. There's also circumstantial evidence. Okay? Circumstantial evidence means using that direct evidence, so those photos, that testimony, those videos, the drugs, to infer other facts reasonable and also justifiable. Take your time, ladies and gentlemen. Common sense is important. That common sense, I imagine, comes into play when you're looking at circumstantial evidence. 1 + 1 = 2. Now, we go to the right of the screen. Direct evidence and circumstantial evidence mean and weigh roughly the same. Take your time. Again, use your common sense. Refer to your notes. Refer to the testimony of these witnesses. Refer to the evidence before you. Now, again, as we continue to talk about circumstantial evidence, this is a photo, as you can tell, of a dollar bill. Now, there are pieces missing, yes, but that doesn't mean that you don't know what this is, because you have common sense. Now, in the state's case, there may be some pieces missing, but you have common sense and you can say it is what it appears to be. Take your time as you look at this, and you know what you're looking at. Take your time and look at the state's case, and you know what you're looking at. Now, some of the direct evidence that you may have heard, Officer Philemon came before you as the state's first witness and explained to you in testimony and on body cam that the defendant confirmed that the item belonged to him. Is that your stuff over there? Yes. Cameron McCall also testified that the defendant said that it was his stuff. Officer Philemon also confirmed encountering the defendant covered in blood. There are several tangible items. The 911 call for the underlying domestic issue. The photographs of the defendant's belongings outside of Cameron McCall's residence, covered in blood. Additionally, the ring camera footage of the defendant putting his belongings outside. Circumstantial evidence. As Attorney Nix stated earlier, the opening of the state's case, that the theory was that the theory of the state's case is that the defendant was caught red-handed. Circumstantial evidence there is that the defendant was found covered in bright red blood when law enforcement arrived. Then we look to the things in the hallway that are also covered in blood. And then inside of those things covered in blood is cocaine found inside of those belongings, inside of bags that are also covered in blood. Use your common sense. There's direct evidence and there's circumstantial evidence. Weigh them appropriately, but use your common sense. Now, the testimony of a single witness is sufficient, if believed, to establish any fact. That means that when Officer Philemon came before you, if you believe her testimony to anything that she testified to, that means that you can believe it to be a fact. That means that nobody else has to come forward and say, she's telling you the truth. It means that if you believe her, it is enough to establish that what she says is factual. Again, I go back. Use your common sense. It means that the testimony of Cameron McCall, if believed, is sufficient to establish a fact. The testimony of the expert witness, the forensic chemist who sat before you, both before and after lunch, it is sufficient to establish a fact. Again, we'll go back, use your common sense. Now, you all determine the credibility of the witness. Now, some of the witnesses, this happened a couple of years ago, a few years ago. Some of the witnesses' memories may not be what it might have been. However, you determine their credibility. Now, as a reference, there was an expert witness who came before you, Mrs. Summer Hutton. Experts are those who, because of their training and experience, possess knowledge in a particular field, not known to the average person. Law school, not math school. She came before you and testified to her training, her experience, and her education in forensic chemistry. Utilizing that knowledge, she was able to make determinations. Now, the testimony of an expert, like that of all witnesses, should be given only the weight and credit that you believe it should have. But again, the testimony of a single witness, if believed, is sufficient to establish a fact. Summer Houghton, through her expert testimony, knowledge, training, and experience, was able to explain to you that she tested the drugs submitted to her twice. She confirmed the amount, the purity, and the weight. Look to your notes. Look to the testimony, look to the evidence. Most of all, use your common sense. Now, one of the principles that we must discuss is possession. Write it down. Possession can be actual and constructive, so joint. Now, actual means that at the time of the crime, the defendant knowingly had direct physical control of those things. Or that they had constructive possession, which means that at the time of the crime, the defendant didn't have direct physical control over the drugs, but did knowingly have both the ability and the intent to exercise control over those drugs. I am in constructive possession of my car, which is in a parking lot. The keys are in my office, but I intend to exercise control at some point today, which means that I still possess that thing. Now, it can also be sole or joint. Sole, meaning that they are the only person who had possession of those drugs, those things. Or testimony that inside of those bags were prescriptions that at least 2 officers read a name from. Not different names, one single name. Those bags covered in blood. Only one person was on the scene covered in blood. Or possession can be joint, which means that it is shared by one or more persons. State believes that it has shown and proven that the defendant exercised constructive sole possession of those drugs. Again, use your common sense. Now, there is but a single charge here, which is trafficking in cocaine. Again, the judge will instruct you on the law. However, we must prove beyond a reasonable doubt, the state must prove beyond a reasonable doubt elements of the crime of trafficking in cocaine, which are as such. The defendant unlawfully and knowingly was in possession of a quantity of a mixture of cocaine, and that mixture was at least 10% of purity. And the weight of that mixture was 200 grams or more. You heard testimony this week. The state believes would allow you to render a verdict in our favor. Now, Lady Nix comes to speak to you soon. She'll go more into depth, but again, use your common sense. Lady Nix submitted to you the state's theory that the defendant again was caught red-handed. Use your common sense. Thank you.
Thank you, Mr. Peoples. Mr. Hirsch. Your time.
Hi. I don't know what to say. I really just don't know what to say. I was all prepared to give you a closing argument, and then this case just got more Twilight Zone-ish. Do you have any idea, or let me not put it that way, how mind-numbing is it? How mind-numbing is it to think that the criminal justice system is impartial and unbiased and looks at all investigations and treats everyone the same? Their job is not to take the initial investigator's assumption, which he admits was wrong, and just never question it, never try and get any other evidence. Their job is to find all the evidence, not to look at this case, how do we support this initial assumption? Their job is to get all the evidence they can to try and find out the truth. And as this trial went on, a jury trial is like an evolution. I wasn't there. The state wasn't there. The police weren't there during the incident. But it's like an evolution. No matter how much you study the body cams, no matter how much you talk to witnesses or look at evidence, you find out more during trial. And as every page turned and we found more and more, the case got more and more bizarre of how Atlanta Police Department, in this case, just doesn't care. Actually, not caring is fine, as long as you're doing your job. But over and over and over, they let down the people they're supposed to serve. Most importantly, they let Emmanuel Tezera down. They had every opportunity to do a little work, just a little work, so that my client wasn't falsely accused by someone who had motive to falsely accuse him. They had so many opportunities. But the most mind-numbing of all is what you just heard from the Fulton County District Attorney's Office. Unforgivable. The key to this case, to showing positively, we don't have to show anything, but if that ring camera was available, it would positively show Emmanuel Tezera's innocence. And they can't be bothered. A witness is about to testify, says, I have hours of video, ring camera video, which will actually show when those drugs were brought into the apartment. Ms. McCall says he brought those bags in earlier in that day. The ring camera would show that. It's not true. We need that ring camera. She says the ring camera you see is 12, 13 seconds. The bag where the drugs are found conveniently is not in that 12 or 13 seconds because she had put it out there. That ring camera evidence is a smoking gun. If we have it, there's no trial because it exonerates. It shows that my client is innocent and they can't be bothered to look at her phone. She's about to testify. She told them before the testimony, hey, I've got hours of ring camera footage on the phone. Okay, can you show it to me? And then they don't even look. And now she said before to the police officers, I'll send it to you. She didn't do it. So what do? I don't know, what does a law enforcement officer do if a witness doesn't want to or can't share information? I have an idea. Get a subpoena. I have an idea. Ask for consent to take the phone and download the information from it. I have an idea. How about a search warrant? None of these things will be very difficult. There are judges in this courthouse who can sign search warrants. The phone was in this courthouse. It's unforgivable. My client had to go through 3 years of this because they can't be bothered. They don't care, and they can't be bothered to look at a phone. He did. So, the state talked a lot about reasonable doubt, and you heard the definition. But let's get some ideas of what it means. So, there are different standards of proof. Probable cause is the lowest standard, or one of the lowest standards, at least that I'm going to talk about. What is probable cause? That's all you need to arrest somebody. That's what the police need. One person's word is usually enough, no matter how unbelievable, is enough usually for probable cause. That's what you need to arrest someone. All right, so probable cause for arrest. What's the next higher standard? It's called by a preponderance of the evidence. Now, believe it or not, you can get arrested just on probabilities, but by a preponderance of the evidence, it's basically a civil standard. Like if I'm suing someone over money, is it more likely than not that it was your fault that your car went through my house, right? If it is more likely than not, then the plaintiff has met his burden and you're going to owe me some money. So this is a civil standard. Usually money is what's at stake here. Not always, but I'll just write money and civil. What's higher than by preponderance of the evidence? Clear and convincing evidence. By clear and convincing evidence, what does that mean? Well, it means what it says. When is that in play? When do we use that one? Well, if the state of Georgia wants to take someone's kids away because they are abused or neglected, then they have to show by clear and convincing evidence that the children were abused and neglected. For taking one's children away, that's the standard. I'm not gonna write that all down. Now, what's above taking one's children away? You know what we call that? We call that beyond a reasonable doubt. That's how high that standard is. I feel silly a little bit even telling you this, or like I'm wasting your time, because I could probably show you beyond a reasonable doubt that my client is innocent. I can certainly show you that it's more likely than not that he's innocent, but I don't have to show you that he's innocent. It doesn't matter if he's innocent. The state has to show you beyond a reasonable doubt that he is guilty. It's not, is he guilty when your verdict form? You're not going to say choose between guilty and innocent. You're going to choose between guilty and not guilty. Not guilty doesn't mean someone's innocent. Not guilty means the state has not met its burden beyond a reasonable doubt. I think it's a nice luxury for you all that my client is innocent. But the question is, did they prove beyond a reasonable doubt that it's true? So, doubt is more or less what they told you, except they said it is not from unpresented evidence. However, it is from a lack of evidence. So, doubt can come from the presence of evidence, and as the judge will tell you, it can come from a lack of evidence. For instance, if Cameron McCall said to you that I have a ring camera, it will show everything from that day, including when the drugs were brought in, because Emmanuel brought them to the apartment earlier that day, and then she never presents that evidence, that should raise a doubt in your mind. If Ms. McCall has access to the ring camera footage, and my client has said, Cameron McCall put some of the bags out, and Cameron McCall said, I put some of the bags out, right? They both agree about that she put some of the bags out. But yet she only turns over 12 seconds, even though she has it all. That is a lack of evidence which gives rise to a doubt. And you have a reason for that doubt. She controls what the police get. And she opted to give them 12 seconds. Because that's the only neutral part of this whole event for Cameron McCall. Everything else, if it was on video, hurts her. All right, so how do you build a case? Well, a prosecution is like a locomotive. You've seen that here. Why is it like a locomotive? Once that thing starts, it is hard to stop it. It is super hard to stop it. And that's what happened here. It started. So let's look at how it started. It started, the basic assumption supporting the case is wrong. But there's no conductor of this train. Everyone's supposed to do their own job, and if something goes wrong, there's no conductor. There's no one to communicate between the two. So all everyone knows is the train has started. Okay, the train has started. Let's go take tickets. Let's do this. Okay? But the basic assumption supporting the case is wrong. No one knows that the train should not have started. And once that locomotive runs, everyone just assumes, okay, someone else is doing their job. I will do mine, and no one's ever even going to tell me that the whole basis of this case is, as Officer Skidmore told you, based upon an assumption that was simply wrong. In the meantime, Officer Skidmore is talking to my client in the hospital. My client was compliant. He cooperated fully. After being stabbed, after being hit with a frying pan, after bleeding profusely and going to the hospital, he continues to be compliant. And what happened when he was compliant? There's the frying pan in defense one. What happened when he was compliant? He got to be interrogated by Investigator Skidmore who said to him, I saw you with my own eyes take the drugs. No. Nothing he said could change the investigator's mind. But what else do you know? Despite being fully compliant, there was no positive evidence for the state. They gained nothing from having a cooperative person because there was no evidence existing in the world that would help the state's case from talking to Emmanuel Tezera, because he's not guilty. Let's talk about the blue bag quickly. The state seems to think that this blue bag is his. Well, if you look at the blue bag, first of all, it appears as though to me what looks to be like a woman's feet. Maybe it's not, maybe it's a t-shirt, maybe it's skimpy men's underwear. We don't know, because that's a lack of evidence, because they don't have it, they can't show it, they don't know what they did, they didn't photograph it. But there's something else in that bag. If you look at it, this is in Foster's body cam. He's moving through the bag, and this is Defendant Exhibit 22, a little still shot. Right here, there's a little container. I don't know if it looks like, you know, chewing tobacco or tobacco stuff would fit in there, but some sort of round container. And if you look then at Defendant 4 and 5, you will see on Karen McCall's vanity, behind her brush, a similar looking container. Is it the same thing? I don't know, because this is gone, because they didn't do their jobs. That's a lack of evidence, where there's positive evidence, but we can't look at it ourselves because they didn't do their jobs. They want you to have to rely on that. The folks who make assumptions, he didn't just make an assumption, he said, I saw you take the drug with my own eyes. I saw you take the drug with my own eyes. It's just not true. You just say things that aren't true. What else? Inside that blue bag? Well, the white bag, right? The white tote bag at some point is sitting inside the blue bag. And the state asked the officer, Officer Appleton, who doesn't know if you put red tape on the bag or not, but of course he's going to know if it's women's clothing or men's clothing. He says, Officer Appleton, was there any women's clothing? I mean, if you're the officer, just, answer the right. I know they're asking the question, you just want to say yes to them and help the case, but the honest answer is, I don't know, I didn't look through all the clothing. Of course, he says, no, there was no women's clothing. There are pink shorts that look like maybe women's clothing in the green bag, the Publix bag. There is what I think could be a bathing suit in the blue bag, okay? But here's the point. Why does it matter? Let's say it was all men's clothing, what does that show? Karen McCall, on June 11th, 2021, is a biological male. And you know what? It doesn't matter if it's biological male or female. She can wear whatever she wants. She doesn't have to just wear women's clothing. Don't let the state put her in a box. You can only wear women's clothing. No, she can wear whatever she wants, and she does wear men's clothing. You can see it in the video. What else? She tells the officer, hey, I have, this is on Officer Skidmore's body cam, I played it, $50,000 Louis Vuitton bags. Now, she says a lot of stuff that isn't true. Her relationship with the truth doesn't seem to be real healthy. Does she actually have $50,000 Louis Vuitton bags? I don't know. Although, I hope nothing like that existed. I hope there are $50,000 Louis Vuitton bags, but I have a feeling I'm wrong. But she obviously likes Louis Vuitton. Sometimes people say things which are truth and half-truths. What are the drugs found in? Defendant Exhibit 26, it's in the body cam. It's a Louis Vuitton. This is just a Louis Vuitton plastic bag. I'm not saying she was saying the bag, but She likes Louis Vuitton. She told you that. She covets, dreams about having a $50,000 Louis Vuitton bag. Or she does have one. And the drugs are found in a Louis Vuitton shopping bag. So here's the next question. Does that prove anything in and of itself? I mean, it should give you a little maybe question. Hey, that's a doubt. But what do we do with that one little piece of information? Oh, I know what we can do with it. Let's go ask Cameron McCall. I'm a police officer. Let's go ask Cameron McCall. You just told me about Louis Vuitton, and the drugs are found in Louis Vuitton. Hey, why? Why is that? Can you tell me? Of course, that didn't happen. None of it happened. And it's not. And actually, that's not the investigator, not Cameron. He didn't look hard enough. He didn't put 2 and 2 together. He got in, he got out. Right? Philemon had to get out of the scene because you get off in 30 minutes. All right, let's just get you out of here. So the state's case essentially rests upon this notion of blood. And bloodhouse somehow acting like a fingerprint. And I think that's fair. It's actually sounds like a little bit of police work. So let's talk about that. There's blood on the white tote bag. All right. There's blood everywhere, by the way. So, state's exhibit number 10, well, if you look at it and you look at the body cam, you see all the bags. Next to all the bags is a lot of blood splatter because he's standing there at some point. At some point, he's leaning over his bag, bleeding. He bleeds on the ground. He bleeds on the bags. It doesn't mean he put it out there. He bled on the blue Publix bag. And if you really want to follow, green Publix bag, if you really want to follow, do a little forensic investigating, it appears as though he did so after it was placed out there when he was leaning over it. There's no blood inside the bag. His book bag and medication is right next to it. He's leaning over, his blood falls onto the bag just like it falls onto the floor. That white coat bag belongs to my client no more so than this floor does, which also has his blood on it. Defendant's exhibit 24, there's blood all over the floor in her house. He's bleeding everywhere. Defendant's exhibit 25, there's blood splatter on doors inside the apartment. There is blood everywhere. Miss McCall told me she didn't clean up at all. Right, that's what she said on the stand, except she's cleaning up. And just like she's cleaning up inside, she's cleaning off herself, obviously. Obviously, she has to have blood on her. You heard the interaction she described. My client is stabbed. It appears as though, if you look in the ring that video, he's got red stuff on his face is red, his head up here is a little thin, and it looks red there. He's big. I don't know if there was some grease involved. It appears as though she threw some grease on him, some bleach, and she describes that at some point he pushed her and they're jostling. There's blood on the floor, there's blood on the couch, there's blood on the door. They're in close proximity. Obviously, there's blood on Miss McCall. So when they say, the state says, oh, who had blood on them? The answer is, at the time the bags are put out, both parties do. And this is confirmed by Officer Philemon, who said, yes, I was talking with her, I didn't see any injuries, but she did have some blood on her. All right, obviously she washes it off. She has 2 people there in the apartment, cleaning the apartment. The first thing you do is clean yourself, and if someone else has blood on. blood on the outside door, there's blood on the stove. And after all this, a manual cooperates. It says, yeah, this is what happened, take me down to the station, okay, I can't take my stuff, right, he's in custody down at the station, and he cooperates, I got nothing to hide. I have nothing to hide. Karen McCall, on the other hand, hides information. She says she has ring camera video, and she doesn't turn it over. Oh, this is the Louis Vuitton. I just wanted you to see how great my artwork is, but if you see me write it all, you know that's not mine. All right. Direct and circumstantial evidence. So I'm going to call this two theories. All right, and this is first of all, the state's going to tell you what the law is. I'm going to tell you what the law is, and basically what we're saying is neither of us are experts on the law, or neither of us are authorities on the law. Nothing the state says is actually the law. Nothing I say is actually the law. The law comes from the obvious expert in this courtroom, Judge McBurney, but we're both telling you what we expect him to tell you. And one of the things we expect is that evidence can be direct or circumstantial. Both, right? But to authorize a conviction, it has to exclude all reasonable theories of innocence. And it would have to prove, he's not going to say man, he's going to say the defendant. I think it would have to prove the defendant guilty beyond a reasonable doubt. It has to exclude every other theory in the world that he's not guilty. Every one. All right, so are there any other theories other than the drugs are his? Before I get there, my client at the hospital, he's apoplectic, you see he has lots of medicine, he's cooperative, and the evidence the state gets from that is zero. They get zero helpful information to them, because he's actually innocent, from my client's statement, from my client's phone, from my client's computer. So when you're judging what happens here, I think you need to look at who the witnesses are from the state. I don't even want to say any of them are lying. I don't use that word anymore. I used to say lying all the time when I was a little bit younger. This witness lied, this person lied. Lying means you're doing it intentionally. All right, and you can say two different things and misremember. You can say two different things and have a psychological issue. You can believe your own lies. You can just misremember. So the police officers who are up here who consistently got their information wrong, I'm not calling them liars, but they didn't tell the truth. All right, so I just want to be clear. And that happens, all right? But it happens with such regularity here that it's hard to believe anything anybody said in this case unless you see it for yourself with your own eyes. All right, what are some examples? I'll give you three quick examples of that. The officer Foster said the green bag was in the same place. This isn't actually a lie, this is sort of together. The green medicine bag is in the same place when I looked at it as it was when we got, as it was in the original scene. No one moved it. Of course, he doesn't really know, but he's happy to say that no one moved it. But maybe what he said was, I didn't move it. But here's the important thing. You saw all this body taking. At some point, someone moves that green bag from right in front of the doorway to about 25 feet away, where Officer Appleton is looking into it. And despite all this body cam, no one can say who that was or how it was. What happened when it was moved? More importantly, sometimes defenses have to be like, oh, there's a conspiracy and the police are trying to do this and that. I don't get into all that. I don't believe all that. But what I do believe is they make mistakes. For instance, Officer Foster just told you that he is the one who went through the green bag. And I think he did go through it at first, but of course Appleton goes through it first. Foster goes through it at some point. Appleton goes through it first. Here's the key, the super important thing about what Foster said. He said, yes, I took these 3 vials out of the book bag. I took them out and I put them back in. Well, he's wrong, right? Because there's a body cam. We know that. That's why video is so important. If there was no body cam, you'd be stuck with all this misinformation. And the police would believe it. So he says, I put it back in that backpack. He's simply wrong. Fine. But what does it mean? Well, he's wrong, of course, because you saw Appleton come over, take those 3 things, take it from the backpack, walk about 25 feet, and decide on his own to put it in the green medicine. Foster said, not only didn't I do that, I wouldn't do it. Of course you wouldn't do it. Why would you move something from one bag into another? It's absolutely wrong. It's not where the evidence is found. But it happened in this case. Well, what else was moved into that green baggie then? The scales in the baggie? These are pieces of evidence that there is a doubt for, because you cannot trust their recollection. And in fact, the body cam often shows that they just don't know, they're not telling the truth. The red evidence tape, how does this even happen? I just don't even, I mean, this is depressing to me as a citizen. Like, how does this happen? I mean, it's so simple. You put the drugs in the bag. You wrap it in evidence tape. The crime lab says you should initial it. APD says, we don't know to initial it. Fine. It doesn't matter if you initial it or not. It's a second layer of precaution. The red evidence tape means it's evidence. It means if someone opens it when they're not supposed to, the tape is broken. Officer Appleton sat here and swore to you under oath that he put red tape on it. You know why? Because he knows that's the right thing to do. Did he know he didn't put red tape on it? Probably not. I don't think he was lying. He didn't tell the truth. What's the significance? These precautions are here for a reason. And when they just tell you things that are untruthful, it should make you doubt each and everything they say, unless there's video evidence for it. What else? Who is RD? Right? The crime lab said they initialed it themselves. That's this blue sticker, it appears, right? They initialed it themselves. It came in uninitialed. And then, well, that's what the crime lab report said, but then Mrs. Hutton, chemist Hutton, said, oh, they had initialed it, it was just underneath RD. Who's RD? How did he get this bag before it got to the crime lab? How did the evidence tape get on it? The chain of custody is obviously broken. What does that mean? It means it goes to the weight. You can still consider it just goes to the weight, not of the drugs, the weight of the evidence. Do you trust these folks enough to think that that is the right amount of drugs from the right case? All 338 grams that they put into evidence, all 338 grams that they put into evidence. Of course, the crime lab report came back at 295 grams. I asked the chemist, hey, you don't weigh it with the bag. Like, I'm giving her the answers. I want the truth. The truth helps my client. I don't want to trick anyone. 295 grams, but you don't weigh it with the bag, right? Because like there was this difference. Yeah, we don't weigh it with the bag. All right, so there's a difference. What is a bag weigh? About 5-6 grams. Well, I think a little bit more than that. Do your job, somebody. An investigator from the Fulton DA's office, somebody come in here and say bags weigh 40 grams. I mean, I said 5 or 6, she said a little bit more. Well, then there's some missing drugs. I'm telegraphing what my defense is. I'm giving you, okay, but bags weigh something, right? 5-6 grams. And they just can't connect the dots. They can't connect the dots. You should not trust them to take someone's liberty away. If you have any doubt, a single doubt based on reason, I'm gonna talk about Cameron McCall a little bit just because, obviously I need to. She has a, loose, relationship with the truth. That's what I'm gonna say. So what are my instances of this? And it doesn't matter why. It doesn't matter if she's lying. It doesn't matter if she's misremembering. It doesn't matter if she is subconsciously saying something because she knows she could be charged with trafficking in cocaine. She knows the mandatory minimum for that. If she got charged with it, it's 15 years in prison. It doesn't matter necessarily why she has this loose relationship with the truth. It matters that it affects her narrative and her accurate testimony. So what are examples of that? She said she called 911. I mean, obviously, it's my client called 911, right? He's the victim. But she said she called too. The officer said no, there was no other calls. She said on the stand, she didn't know anything of drugs until Emmanuel said, hey, come get my stuff. Come get me and my stuff. And she put it all together. But at the scene, she says she's tired of dealing with a drug dealer. Get your Molly, weed, coke, and shrooms out of here. I mean, you just can't believe anything she has to say. And how does she know? She's wrong about the Molly, it looks like. How, unless one of those bags is Molly. If one bag is Molly and one bag is coke, then they're under 200 grams, right? Each bag is under 200 grams. So if she's right, when one is Molly and one is coke, then you have to find him not guilty, or anyone not guilty who was charged with this. But she says, get your, how does she know exactly what's in there? All right, it's a rhetorical question, you guys can't answer, I won't give you the answer. FaceTime, I was FaceTiming with my mom. My mom says, go call a relative. At some point she's talking with her dad. Her mom says, according to her, call your aunt. Can we please corroborate just one thing she said? Can we maybe call her mom or her dad or her aunt or Anija or Kareem just one time? Just for fun, let's try and do some work and corroborate what she said. She said that when the officers arrived, Anija and Kareem were outside the apartment. Now, why would she say that? I mean, she could be mistaken. But why would she say that? Because she knows what they were doing inside the apartment. They were helping her clean up. If she had other stuff, they were helping her get rid of it. They were helping her because she has a guilty conscience. And what's in that white bag? What's in Anija's white bag? It wasn't there when she was at the scene coming out of the apartment. She had no bag. And somehow later, the officer tells her that they can leave. And about 15 minutes later, she's there. She's back in the scene. She's exiting the apartment, and this time she's got a white bag. I call it a white bag. It might have some gold, it might have some sparkle, but she has a handbag. What's in that handbag? Why was she allowed back in the apartment at the scene? Miss McCall tells you that Emmanuel moved the bags to the garage. They weren't outside the apartment. They went to the garage. Just her memory is, or her, what is to say, again, unless it's on video, you can't know that it's the truth. But the good news is everything that happened is on video. It's on the ring camera that she won't share with the police, and that the police won't go get. Chasing all over the complex, it seems like new info, and Anija and Kareem saw it, and Anija and Kareem weren't here. She just made it up. There's only blood 25 feet in front of her door. Why make it up? I don't know. I think things just grow in her head. The more she can be the victim, the better. That's what she told me. She wants to be the victim. I mean, she said that. She said, well, I was being treated outside. Someone says, or she just explained why she said that there were drugs in the bag. I was being treated outside and he was being treated better than me. When I was the one who was wrong. Right? She sees herself as a victim no matter what happens. She has no injuries. This thing about her having a mark on her neck is inconsistent with how she said he even touched her. She says she was in a headlock trying to struggle, so she has no injuries. My client is stabbed. She admits she hit him over the head. She says she hit him with the pan. She admits she broke the vase or the marble thing. I mean, his injuries were obvious. She has no injuries. She's the one who was wrong. He calls 911. She's the one who was wrong. And this thing about, there's proof positive out there about who brought the drugs into the house because it's on ring camera that she won't give over. I mean, the cases really should be over like that. But in addition to that, story doesn't make sense. Like, we've been dating for 2 weeks. I've known him since Monday, and now he's bringing all of this stuff over. I bring a couple of bags. In that blue bag, where the white bag was something like 6 or 7 razors. He's not moving in. He was staying there for a night. She says that she put stuff outside. She at first lets the police in, and then when she realizes that she might be in trouble, she revokes consent. No, you can't go in there. My friend, you go in there. You go in there. Officer, you can't tell her what to do. You go in, Anija. So she later gives consent. Yeah, after she's threatened, and I shouldn't use that word. After the police tell her that they're going to go get a search warrant, if she doesn't leave the key, they'll break the door down. Well, if that's what's going to happen. Why revoke consent after you've given? You're worried about what they might find. What might they find? Stuff in the bedroom, maybe. Officer said, hey, anything we need to look at in the bedroom? No, nothing happened there. Okay. And there's nothing, no pictures of the bedroom. There's nothing from the bedroom pictures. Don't look. All this happened, by the way, after she said something about trans people getting murdered at truck stops or, or whatever the language was. And that is horrible. But it hit a nerve with Officer Skidmore. Just easier to do it this way than have someone shouting at you like that, maybe getting canceled. Who knows? Maybe it's white guilt. I don't know. But after she said that, everything changed. His demeanor changed, and he just started rolling over for her. Just started rolling over for her. And then the charges were gone. And this is one of the best aggravated battery cases in the world against her. I mean, could you get a better aggravated battery case against Cameron McCall? They just dropped it 2 years later. What's the deal? Remember, a single doubt is enough for you to acquit any doubt whatsoever, as long as it has a reason for it. I mean, you can't say, oh, I think there's a doubt because he's got a nice colored suit on. You can't say, oh, I have a doubt because I work at Lazy Boy and he's suave looking, right? That would be a capricious doubt, an arbitrary doubt. The doubt has to be reasonable. You just have to give a reason. Let's say you have a grave suspicion. You're like, well, I don't know, it's a little bit much, it's a little close. I have a grave suspicion. That's not enough. Evidence that merely places on the defendant a grave suspicion is not sufficient. So let's say you think, I think he was even more likely than not involved and knew about it. Then you have to, it will be your sworn duty to find him not. Remember, the evidence has to exclude every reasonable theory in the world of his innocence. My client didn't testify. The court's going to tell you that he doesn't have the burden of proving anything, and you should not consider that he didn't testify. But when I say he didn't testify, I mean he didn't take the stand in the court. All right, he cooperated fully at the time, was questioned and treated like a criminal after being stabbed, hit over the head, bleeding everywhere. He had a case against his accuser dumped for no reason. If he's a little reluctant to talk to law enforcement. He's already shared everything with them. This issue about constructive possession, it can get a little confusing. But one thing to remember is for a person to have possession, they have to know it's there and they have to own it. They have to be involved with it. They have to know it's there. They have to intend to possess it. So if I'm picking up a blue bag, if I'm hastily picking up a blue bag or a Kleenex or a box of gloves, and inside of it is an envelope, and I just grab it and throw it outside because I'm in a rush, but I don't know what's in the envelope. Did I possess it? Yeah, well, I have it in my hand. Did I know or intend to possess whatever inside here? No, I don't know what's in here. There's no blood on any of the drug bags, right? There's a drop of blood, I think, on the pillowcase. Which, by the way, again, playing Monday morning forensic investigator, the tote bag has a lot of blood on it, like it's being dripped on. That little, the white bag has just like a fingerprint, as if someone who was a victim might have touched it, or maybe one of his drops of blood got on it. But if that is their evidence, that is what is linking him to these drugs, then this is obviously not guilty. Oh, there we go. Mere presence, just because he's there, just mere association with Ms. McCall is not enough to convict. Possession. Possession, actual and constructive, can be a little confusing. So right now, I'm talking really to the jurors who might be on the fence. Like if the jurors, when they deliberate, are like, oh my God, this is easy offenses, right? Obviously, then I don't need to convince you of anything. So my target audience is here. People may not be there yet. So some folks, a reasonable person might say, well, it seems to me, just the way things happened, that he at least knew. I'm sure he at least knew that Cameron McCall had those drugs. If that's what you think, then it would be your duty to find my client not guilty. Doesn't matter what anyone knows, they have to participate, they have to have knowledge of drug transactions. What if someone said, you know what, those baggies could be his, and I know that those baggies are used sometimes for like selling drugs like marijuana or Delta 9 or CBD, some sort of flower. So I think maybe he had these bags because he has access to baggies because he's epileptic. Again, I don't think any of you should think all this, but if he did, but I don't know if he was giving it to her because she was selling marijuana. But I don't know if he knew about that she had cocaine. If somehow you got as far as I said, it would be your duty to find him not guilty. Because even if he had a bag and somehow was giving them, for what? Right? She says, and we know that she smokes marijuana, and they were together and shares that. Well, presumably it's hard to smoke and have stuff out and not share it. So, the scale on the bags. There really is no case here. And then you find out about the scale on the bags. What are reasonable inferences you can make about the scale on the bags? Well, one is it wasn't his. It got mixed up, just like the drugs got mixed up. And even though, you know, that may not be the case, I think it's more likely than not that it didn't get mixed up, like the drugs got mixed up, the prescription drugs. I have a doubt based on reason that the scale wasn't his. What if you know that he's epileptic, which you do, and that he's got medication for that? Well, you don't have to be an expert in epilepsy to know that you might need an emergency plan. If you have 8 different bottles and you saw his pill box, you have 8 different bottles of medicine. And if you have a seizure, you need some of that medicine, you can't take all your bottles with you everywhere you go. It's an easy thing to do. Put pills in a bag, you can put them in your pocket, they might get linty, they might get wet, they might break, you can put them in a bag. What about the scale? If you think it was his. Sometimes people have scales, some people weigh their food, some people who have medical conditions watch what they eat and how much of it they eat. They might need a scale for that. They might need a scale to weigh liquid, medicine. They might need a scale for a variety of reasons. In fact, I think they're called kitchen scales. Again, there is no evidence, good evidence, that the scale and the bags were his. I'm talking to somebody, if I had to try and imagine in a world based on what they presented, trying to imagine the world who I should talk to, those are your doubts. But you don't have to have any of these doubts. If we just had a video, all we need is a video. But we had the camera McCall decided to erase it or not to turn it over. Okay. And my last bit, I'm just going to talk about the lack of evidence. Lack of evidence for reasonable doubt comes from the presence of evidence, and of course, the lack of evidence. Follow the money. Come on, follow the money. Investigation 101. If someone's buying drugs, you want to know who it is for sure, look what their bank account looks like. Look to see what their job is. Look to see what their watch looks like, their car looks like. Are they buying groceries in cash? Like if no one buys groceries ever, then they're using cash because they're getting deals, they have cash from drug trade. We just follow the money, do something. Look at the bank accounts. If they had only done that, they would have seen Cameron McCall appears to be leading the life of someone selling drugs. $50,000 Vuitton shoes, cars. She says she has a trust fund. Well, you know what that means? It means one of two things, Robert. One, she has a trust fund. It could mean that. Or it could mean she's trying to give a reason why she has so much money and no job. Because the real answer to that question is, I make money from selling drugs.
So you have a little less than 10 minutes.
I won't need it all. Follow the money, follow the texts. Drug dealers, people who deal drugs, have to communicate with people they're selling to. They may have multiple phones. The manual had one phone. Look at the texts. That would have helped exonerate Emmanuel Tezera when she has texts talking about drug deals and he does not. Look at the phone calls. She said, Cameron McCall said, hey, he called someone and said, come pick me up. Look at his phone, see who he called and find out who that is and what they talked about. Do a search warrant. Hey, what about his computer? Look at his computer, open it up, get a search warrant if you need to, and see what he's investigating. See what he's looking at. What website is he looking at? Is he looking at websites about expensive things? Is he looking about websites about drugs in Georgia, about how to get it gets detected, about punishment? And when he's not looking at any of that, which Emmanuel Tezera wasn't, it's a lack of evidence. I was not invited to the crime scene. That's normal, right? Obviously, I'm not invited to the crime scene. The government has to do all this stuff to protect everybody. They have to do this to protect everybody's rights. That's one of the reasons this burden is so high. Our Constitution demands it. Our Constitution demands that we keep these rights protected, and the police have got to do their jobs. If they don't do their jobs, the Constitution and the rights for everyone are in jeopardy. These folks can't seal a bag correctly. My client is being sent. which I don't have to show you. And I can't, because Cameron McCall destroyed the ring camera. What I can show you is he is not guilty. Thank you.
So we got a little more than 30 minutes remaining for the state. You all able to make that before we break? Great. Ms. Nix, you are up. I need you, Mr. Hirsch, to take down the poster and the easel, please.
Yes, absolutely. Let me do that first and then I'll return these.
Okay? I appreciate you using the easel. It's been every day I've been on this job that no one has used the easel.
I
Oh,
had to screw it back together.
yeah, I bet. It was probably covered in dust.
Folks, this is not CSI night. This is not CSI Atlanta. We're not in a TV show. We're in the real world. I used to tell people, you know, my dream job? TV prosecutor. Because they always look gorgeous. They're always so goofy, they always have the perfect line, come back. And all the evidence is perfectly laid out. And there's all kinds of time to get every single thing you could possibly ever want. Doesn't exist. It's not the real world. Investigators Skidmore told you that. You know, we would have loved to have evidence tape, police tape. They didn't have police tape. He said we would love to have police tape so that we could cordon off this crime scene. But we didn't, because it's not a perfect world. He said we have to deal with what we've got. These officers, they're not narcotics officers. They're not coming to this apartment saying, I'm gonna get myself a drug case. No, they're responding to a 911 call in which the defendant says, I got my stuff out here. I got in a fight with my girlfriend. I got some injuries, I'm cut, I'm bleeding. They're responding to a domestic fight. Officer Philemon responds to a domestic fight. She's making sure that the defendant's okay. He's bleeding. She told you her concern was him, was making sure that he was okay, that he was getting medical attention. She thinks she's responding, she's responding to a domestic fight. Investigator Skidmore is responding to a domestic fight. He kicks the door to try to get Cameron McCall to come out so that he can investigate this domestic fight. She tells Investigator Skidmore, and she told you on the stand, that they were in a fight. She says, yep, I hit him with a frying pan. I hit him with this marble tray vase. You saw the shards of it. She says, yeah, I hit him with it. That's why he's bleeding, because he was attacking me. She tells you that. Now, folks, the reason the officers were there is because of this fight. But the reason that we are here today is because officers found drugs after this fight. We're not here about the fight. Mr. Hirsch said that a prosecution is like a locomotor. Once it starts, you can't stop it. But we're not here about the fight. We stopped that because we didn't have the evidence. When officers respond, they investigate, they make decisions, and then they turn over what they found, what their conclusions are, what they think, their evidence to the district attorney's office. We take it from there. We look at what they've given us. If there's anything else we need, we try to get it. If we can't get it, we can't get it. And if we don't have the evidence of something, we don't go forward to prosecution. We didn't have the evidence to charge Mr. Tezera with aggravated assault. He was arrested for aggravated assault, you heard that. We didn't charge him with that. This indictment is not for aggravated assault. This indictment is not about that fight. That fight is the reason officers were there. That's the only reason it's relevant to this. So we didn't have the evidence for the aggravated assault against Mr. Tezera. We didn't have the evidence for aggravated battery against Ms. McCall because they were fighting each other. And in those situations, you can't just charge, we can't just charge someone, both of them. Yeah, we are required to figure out who is the primary aggressor, who was the initial aggressor, and we were able to figure that out in this case. And so the prosecution for the fight ended. There are no current pending charges for either Mr. Tezera or Ms. McCall about that fight. The only charges that we have are because after officers responded to this fight, to these non-narcotics officers responded to this domestic fight, through the course of their procedures, their protocol, their inventory, Mr. Tezera's stuff, because he's been taken to the hospital after this fight. They find the drugs. That is the only reason that this case has continued past when we determined that we didn't have the evidence to pursue charges about the fight. Because we had the evidence only to pursue charges about the drugs. Mr. Hirsch has made a lot of hay about this fight. And whether Ms. McCall is trying to get Mr. Tezera in trouble. If somehow Ms. McCall decides that she's going to get Mr. Tezera in trouble for drugs and puts these drugs outside, wouldn't you expect the 911 call to have come from her, not from Mr. Tezera? Wouldn't you expect well, let me kind of come back. All right, let's talk about the fingerprints that several of these officers were asked about. CSI, the crime scene investigators, they really only respond to violent crimes. That's the reason why they responded to this one. I've been in this office for years. I've never seen CSI respond to a drug case. Because they respond to violent crimes, they might do a fingerprint analysis if it's relevant. But in this case, at this point, when CSI is there when these photos are taken, nobody knows anything about these drugs. This is a domestic fight. This is a aggravated assault, aggravated battery. They would get fingerprints potentially if there might be some that they could get, because they might need to know who was involved. We know who was involved in the fight. But both of them were still on scene. It's Mr. Tezera and Ms. McCall. We don't need to do fingerprints to know who's involved in this fight. We know they're both there. They're both saying, yeah, you hit me, I hit you, all this. You know who's involved in this fight. The defense wants to blame Miss McCall for these drugs. But someone was trying to tell Miss McCall not to come to court. Wasn't me. There were forces that were trying to tell her, you don't need to come. Mr. Tezera loves you. If these drugs really were Miss McCall's and she was trying to get him in trouble, wouldn't the defense want her to testify? Wouldn't they want her to say, yeah, I'll come, I'll testify? Beyond a reasonable doubt is not terribly complicated, but it's something that you may not know because it's a legal term of art. And so for you to find the defendant guilty, you would have to find beyond a reasonable doubt that the state proved all of the elements of the charge of trafficking in cocaine. That reason, if you were to find any doubt, there would have to be a reason for it, and it would have to be based on the evidence. Mr. Hirsch said that our case is relying on assumptions. There might have been some assumptions at the beginning. We're way past that. We've based our case on evidence. We had to prove to you, and we have proven to you, that the defendant unlawfully and knowingly was in possession of a quantity of a mixture of cocaine, that cocaine being at least 10% purity, and of a weight of at least 200 grams. Let's talk about unlawfully and knowingly. Notice we got him red-handed. He is the only person that we have seen with red hands. He's got all over his hands. You can see it. We see him putting his belongings outside. And Mr. Hirsch says that we couldn't see the bag that the drugs were in this video. It's right there. It's in that video. Also in that video is the green duffel bag that officers found the baggies and the scale in. You see him putting it outside. You see the white bag, look, it's right there. You see the blood on it? Right there. You hear him tell the 911 operator, this is my stuff. My stuff's in the hallway.
Okay, can you tell him to come back, cause my mom, like, I have my stuff outside all day, and I've been cut, I'm bleeding like crazy.
We're not relying on assumptions to say that this stuff is his. He tells us over and over and over, this is my stuff. He tells 911, this is my stuff. He tells Officer Pillman, this is my stuff.
That's the stuff right there.
concerned about his stuff. Wanted to call his dad to come get it. She was concerned about him. He wasn't concerned about him. He was concerned about his stuff. We saw him with the green duffel that had the scale and bag in it. And now we see Officer Foster finding him again. We saw this bag, this blue tote, let's call it a tote, white bag inside there. The defense says that's my stuff. He put the laptop right there on top of it. That's his stuff. He's collecting his stuff. He was in possession of a mixture of cocaine. Now, I got nothing in the box. But if I had, let's say, okay, I had this. Am I in possession of this? Yeah, everyone can agree. I'm in possession of this fucker. Am I in possession of my iPad? It's in my bag. Yeah, I'm in possession of it. It's mine. It's in my bag. My bag's right there. Doesn't have to be, you don't have to find the drugs physically in his hand, in his pocket, for him to be in possession of it. It's in his stuff. He says that's the stuff. The drugs were found in this bloody bag. You see that the handles covered in blood, fresh blood, bright red. You know, when blood's been sitting around for a while, it kind of gets brown. This is fresh. And it's on the handles. He didn't just drip on this bag. He is tying this bag up. He is picking it up. He is manipulating it. He is trying to tie that bag up. This is the bag that the cocaine was found in. There's blood on it. That's the cocaine. These officers weren't expecting to find cocaine. They told you. They were expecting to find clothes and toiletries and shoes. They found that stuff. They also found cocaine and marijuana and mushrooms. Mr. Hirsch has tried to tell you that we don't know what happened to the cocaine from when Officer Appleton, he's not a narcotics officer. He's responding just to do the inventory. Trying to tell you that we don't know what happened to the drugs. Right here. Right here. Same drugs. Same drugs. Might try to say, well, we don't know exactly which person had it for every single second from when Officer Foster found it in Mr. Tezera's stuff until today. But Mr. People showed this to Summer Hutton. She said, yeah, those are drugs are tested. Little containers. I put those in there. These are the drugs I tested. Officer Appleton, we showed him these drugs. He said, yep, those are the drugs that Officer Foster and I pulled out of Manuel Sarah's stuff. Officer Foster, yep, we showed it to him. He said, yep, that's the same drugs on the body cam. These are the drugs. These are the drugs that were in Emmanuel Tezera's stuff. Summer Hutton told you it's cocaine. She's an expert. I don't know how to look at something and say, what is this? White powder. She's a chemist. She does, based on her training and experience, she gets She does her test that she told you about, and she says, yes, this is cocaine. She does her test that she told you about to say, what is the purity of cocaine? And she said, yeah, it's over 50%. There's a little error in the original purity calculations, so they fixed it. They noticed when they made a mistake and they fixed it. She waited. Now, I think officers had originally said something like 330 grams. And the reason why GBI tests it, not the officers, is GBI has training in how to get an accurate weight. GBI has better instruments than APD. So GBI is the one that tells us this was 295 grams. That's why I rely on what GBI says, because they're the experts. So here we see Officer Foster in that bloody bag, the bag that is soaked in blood from Mr. Tezera.
So you've got about 10 minutes.
We see that box he finds the suspected mushrooms in. It's the same kind of box that he finds the scale and the baggies in. It's not the same box, but it looks the same. It's the same kind of bag, same kind of box. We had to prove the purity of the cocaine was at least 10%. This was Ms. Hutton's report. One of the bags, 51.6%. None of the bags, 58.9%. That is her second test for one that did not have a mistake. Because they found a mistake and they fixed it. She says this is cocaine. Analysis confirms the presence of cocaine in the sample testing. Schedule 2. Analysis confirms the presence of cocaine in the sample testing. Schedule 2. Cocaine is a Schedule 2 drug. She weighed the drugs. 2 bags. One is 176. Other one is 118. Add it together, 295. I can't do math in my head, so I use a calculator. 295 grams. 295 grams of cocaine in the stuff that belonged to Emmanuel Tezera. We know it belonged to him because he told us. We see him putting it outside. You see him gathering it when officers first arrived. Folks, there's no reasonable doubt. We know who these drugs belong to, because we know whose stuff they were found in. We know that it was cocaine, of a purity of more than 10%, and over 200 grams. Never had told that. These are the same drugs someone tested, and Ms. Hutton tested, as Officer Foster found in Mr. Tezera's belongings. And so, we're gonna talk to each other, remember all of the evidence that you've heard over the course of the last few days. And I'm confident that you will come to the same conclusion that Mr. Beasles and I have. That Emmanuel Tezera is guilty of trafficking in cocaine. Thank you.
Thank you, Ms. Nix. All right, I'm gonna give you all a quick break just so we can reset the screens. I'm gonna get the jury charge up. During the break, please talk about this. I will charge you, it'll take 15, 20 minutes, but that'll get us into the 4 o'clock hour. You, once you begin your deliberations, have much more control over your destiny. If you want to stay late because you're deliberating, we stay for you while you deliberate. You may say, Judge, it's a natural break. We heard closings, we heard the charge. We wouldn't finish tonight anyway, so why don't we start fresh tomorrow morning? I don't make that decision for you. You all make that decision. So I know you haven't heard the law yet, but just huddle up a little bit. That's not constituting talking about the case. That's procedural, so you can talk about that. About whether your preference would be, let's deliberate for a little while tonight, or at least go to 5 or go to 5:30. And I ask only for planning purposes. You may get back there and decide you want to go later. I think we max out around 7. When does the shuttle stop running? 7. So there's no reason we can't go up until then, unless you have a reason not to go up until then. And so if any one of you has I got to stop at 5, just share that with your group, because it may be we don't want to have you deliberate for 5 minutes today, only then to break and come back in the morning. But we'll talk about that as a group after I've given you the charge. Okay?
All right, so jury.
All right, we will take a break in just a moment. A couple things. I'm going to give, when we start the break, to Ms. Rivers, cards 1 through 50, 50. That's how many, you can be seated. Juror cards were submitted. This will be Court's Exhibit 1, all 50. There were a few that weren't posed to witnesses, but they'll all go into evidence as part of the record. The second thing I'd ask is, if you, Mr. Peoples, I'm nominating you just because you seem most hassle with the technology, if you could see if there's a way to get all of the videos onto a thumb drive. It doesn't need to be a thumb drive that's in evidence, but there's now technology in the jury room where jurors can watch videos without having to sit out here and not interact with each other. It is a computer that has on it only Windows and a way to play videos. There's no internet connectivity. And so what I do is plug a thumb drive in there, and then we push all the videos onto the desktop, take the thumb drive away, and then it's a static system. They can play what they want to play, and don't need to come out here and be fed it spoonful by spoonful. I just don't know if that's 100,000 gigabytes if you take all the videos.
So, the video that is Officer Suk's is the only one on a jump drive, because it was the largest, and I put that on, I think, a 30 something gig.
32.
And so I believe that there is enough room left on there for me to put the rest of the videos, and I've got them on my computer.
Great.
So
Oh, then that's even easier. You could see what you could fit on there. Otherwise, if you've got a blank one, or I can get you a blank, I'll find the biggest one I can in my drawer of thumb drives. But ideally, if they fit on 2, that's fine. We're just dragging and dropping onto the machine that is on the back of the big screen in the jury room. So if you have a way of consolidating it onto the one that's in evidence, all those are going back with them anyway. They will get the thumb drive and the discs. But I plan to explain to them that we'll put it on that machine so they can watch it as they see fit. So if one of you could work on that while I'm charging the jury.
I can do that. So is it okay that even though that jump drive has, State's Exhibit, whatever it was, on it, that all the videos are on there, that's okay?
That's okay.
Okay, then if I could start working on that.
All right.
Your Honor, won't we have a continuing witness issue?
With what?
Brent Lang putting the videos back there with him.
My legal research is that photos and videos do not constitute continuing witnesses. And so jurors are free to watch them. And when they're back there, they can actually stop. Hey, stop right there. That looks like blood. That doesn't look like blood. They cannot have those interactions out here. They can have us stop it, but they can't communicate. And so this is new. There are a couple of us who got this equipment installed, and we're going to see how it works. But I don't believe it's a continuing witness issue. But if you want to make that objection to preserve it, you should, and we'll see where it goes. All right. I don't want to interrupt the rest of your break, although you'll get a long break when they're deliberating. When we come back in just a few minutes, once they're ready. I have copies of the charge for you, and I will charge the jury. Mr. Hirsch, if you'll grab this, one for each prosecutor as well. And I was too quick. I also have a verdict form. If you come grab that, and you all can look at that over the break and let me know. Lastly, if one of you wants to, while I'm charging the jury, try to get the evidence in order, that would be great, so that we have a quick conversation about what goes back and what doesn't after I send the jurors back. Anything, Ms. Nix, before I step off the bench for a couple minutes?
Yes, sir.
Mr. Hirsch?
No, Your Honor.
All right, thank you.
Thanks. Use the restroom, and then if you and I want to get together and
Ms. Rivers?
start playing them.
double check for continuing.
There you go. Thank you. There we go. Mr. Hirsch, did you have a chance to look at the verdict form?
Yes, Your Honor, no objection.
Ms. Nix or Mr. Peoples?
Yes, Your Honor.
Okay with the verdict form?
Yes.
Okay. Anything, Ms. Nix, from the state before we bring the jury in?
No, sir.
Okay. Mr. Hirsch?
No, Your Honor.
Let's bring the jury in, please.
Last question, Your Honor. Is this going back there?
I don't know.
I will say, I had a trafficking case with Judge Browse. It did go back.
I think it should, especially given all the focus on the bags and what the bags say and don't say and the tape.
Are we talking about the bags or the drugs inside them?
Well, it's both. And I don't know that handling the merchandise is something that shouldn't happen, given the way this case has played out. It just needs to not go away. I know firearms can go back if they're made safe. And everything is in vacuum sealed bags. I think should we weigh it before it goes back there?
I was gonna say, if that's the case, how come I'm not allowed to keep it overnight?
Would you just want us to send the gloves back with them?
We should send a box of gloves back as well. So should they want to handle it that way.
There should be.
I like the medium gloves because gloves never fit me and these do.
It's funny trying to get them on Appleton. They sort of like went over 3 of his fingers.
All right, sure.
All those approved accounted for?
Thank you, Deputy Gordon. Everyone, please be seated. Ladies and gentlemen, it's now time for the really exciting part of the trial where you have to listen to me talk to you about the law for a few minutes. I want to say a few things about this, the jury charge. Number one, this document from which I am reading, you will have with you during your deliberations. So feel free to take notes. Don't panic if some of it comes across as a little opaque or legalistic. There are certain things I'm required by law to explain in a certain way. I work hard to make jury charges accessible so I understand them and you understand them. But the higher courts have said certain concepts, you must use these words to define that concept. So I apologize in advance if any of this sounds fussy, but you'll have this document with you. If you need more copies, we'll make you more copies. Number 2 or 3, whatever number we're on, I'm about to put on the screen everything I'm reading. Some people like to follow along. There's no bouncing ball, but paragraph by paragraph, it'll be up on the screen. So again, take notes if you want, if there's a high point or a low point, but know that you'll have this document. Let me see if I can share screen. There it is. Excellent. And let's see if we can get to it. A grand jury has indicted the defendant, Mr. Tezera, for trafficking in cocaine. You will have that indictment during your deliberations. That's this document right here. The defendant has entered a plea of not guilty to the indictment. He signed it and it says not guilty. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. Of course, he's only charged with one. They're not multiple crimes here. It's just the trafficking cocaine. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of the crime charged. There's no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. It's a doubt based upon common sense and reason. Is the doubt of a fair-minded, impartial juror, meaning one of you, honestly seeking the truth. It does not mean a vague or arbitrary doubt, but rather is a doubt for which a reason can be given, arising from a consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all this evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crime charged or merely raises speculation about the defendant's guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. That's what we're doing right now. You are bound by my instructions. You don't get to freelance with them. It is your responsibility to determine the facts from the evidence you have received. You must then apply the law I'm giving you to the facts you find. Now, you should decide this case based only on the evidence presented here in court during trial. And that evidence consists of testimony and exhibits. Evidence does not include the indictment or plea of not guilty, anything said by me or any of the lawyers to include their opening and closing remarks, nor does it include any questions posed. And I flag that because a handful, very few of the questions that you presented were not asked of the witnesses. And you shouldn't draw any conclusions or inferences from that. It just meant they weren't legally appropriate questions. Now, this evidence that you've received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact. That would be what we call an eyewitness. I was sitting there, I saw the car run a red light with my own eyes. Direct evidence. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. Classic example, people start walking in here with umbrellas and they're wet. That probably means it's raining outside. That would be circumstantial evidence that it's raining outside. We can't see outside this courtroom. People coming in with umbrellas and they're wet is circumstantial evidence or proof of some other fact. There's no legal difference in the weight that you may give to direct or circumstantial evidence. They are co-equal. In considering the evidence, you may use your reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of witnesses. In deciding this, you may consider all the evidence, and you have it all now, the witness's manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, their possible biases, and their interest or lack of interest in the outcome of the case. You may also consider any possible motive in testifying, to include any possible grants of leniency. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You heard from an expert witness in this case. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. A defendant who has no burden to prove anything is not obligated to testify, whereas here, a defendant chooses not to testify you may not consider that decision in any way in reaching your verdict. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find this intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Knowledge on the part of the defendant that the crime charged was being committed and that the defendant knowingly and intentionally committed such crime must be proved by the state beyond a reasonable doubt. You may not find a defendant who was merely present at the scene of a crime at the time the crime occurred guilty of the crime unless the evidence shows beyond a reasonable doubt that the defendant committed the crime, helped others to do so, or otherwise participated in the crime. Similarly, you may not find a defendant who merely associated with others involved in the commission of a crime guilty of that crime unless the evidence shows beyond a reasonable doubt that the defendant helped to commit the crime or otherwise participated in it. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. For trafficking in cocaine, the state must prove three things. The state must prove that the defendant, number one, possessed, number two, 200 grams or more, three, of cocaine with a purity of 10% or more. The state must prove that the defendant possessed the alleged cocaine at issue in this case. Possession must be actual or constructive, and also it must be sole or joint. I'm going to talk about all those. Actual possession means that at the time of the alleged crime, the defendant knowingly had direct physical control over the drugs. Constructive possession means that at the time of the alleged crime, the defendant did not have direct physical control over the drugs, but did knowingly have both the ability and the intent to exercise control over the drugs. Sole versus joint possession. Sole possession means that only the defendant had possession of the drugs. Joint possession means that the defendant shared possession of the drugs with one or more others. If, after considering the evidence, together with this charge, you should unanimously find beyond a reasonable doubt that the defendant did commit in Fulton County the crime that is alleged in this indictment, you would be authorized to find him guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. And you would check that option on the verdict form. Here's your verdict form. It lists one count, trafficking in cocaine. And there are two options, guilty and not guilty. If you do not believe that the defendant is guilty, or if you have any reasonable doubt as to his guilt, it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And you would check that option on the verdict form. Whatever your verdict is, it must be unanimous. Your verdict must also be in writing, signed by your foreperson, and dated. That's why we have the form. By no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendant. Your verdict in this case must be based solely upon your consideration of the evidence according to the laws I'm giving you now. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. Ladies and gentlemen, you are the fact finders in this case. You are not to concern yourself with punishment. That is a role for me. One of your first jobs back in the jury room will be to select a foreperson who will preside over your deliberations and who will complete this verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's view. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any research. You have all the evidence in this case. It would be improper to supplement it with any outside information. And to assist you in complying with this particular instruction, Deputy Gordon will be collecting all your electronic devices while you deliberate. That means smartwatches as well. Phones, laptops, anything that connects you outside that room, you'll give to Deputy Gordon. I promise we'll return them. They'll just be making noises in my chambers. But while you're deliberating, they are with us. Going forward, from this moment onward, should you need to communicate with me for any reason, it must be in writing. Use one of those note cards or a page from your pad. Write out your question or concern. Upon receipt of that, I will confer with the lawyers and Mr. Tezera and share with you whatever response I am allowed by law to give. And I add that last proviso because you may have a great question and my answer may be, you have to figure that one out because I'm not allowed to say more on that. Or I may say you'll have to rely on your collective recollection. Because you hopefully remember at the beginning of the trial, I said, we don't replay witness testimony. And so if your question was, what did Officer so-and-so say about that? You'll have to rely on your notes and your recollection. I'm going to add something to that, though. One of the things going back with you all is all the video evidence that you've seen. And there is a device in there that will allow you to replay those videos. You can discuss while you are replaying them. It may be that one of you says, hey, go to that spot when X happened. Now, your question for us may be, which video had this segment or where in this 2-hour video did X happen? Now, some of you may have written it down that Mr. People said 12 minutes and 18 seconds, but we might be able to assist you in finding a spot by giving you a timestamp. But you are free, should you want to play those videos. You just need to let Deputy Gordon know, and we will upload them onto the device that is in the jury room. And hopefully it works. You will be the first to have used that equipment. It's brand new, so don't break it. It's brand new equipment. That is it for my instructions to you all. Before you retire to the jury room to relinquish your electronics, I need Mr. Bapanad and Ms. Mayard. You stay put. The remaining 12 of you, please go with Deputy Gordon. Don't start deliberating until the evidence gets back to you, the verdict form, the jury charge, and the indictment. You can start picking your foreperson or anything like that. And you'll also start handing over your electronic devices. Okay? Thank you. You two are our alternate jurors. You are here as full-fledged participants. You've heard and seen everything your colleagues did. And we always get an extra juror or two because life happens. And on day 2, there may have been a family emergency and we have to excuse a juror. That way we don't have to stop the trial and start all over again with a new batch of jurors. I'm going to ask both of you to stay with us for the rest of today. And then we can talk about whether you need to come back tomorrow or if you could get here on short order, because we could lose a juror tomorrow. And if we do, one of you will replace that juror and they'll start their deliberations over and you'll be part of that deliberating group. But for today, I'm going to let you get your stuff if you have stuff back there, and you're going to go into that jury room there. There's a little hurricane or tornado sign on it. It's safe in there. In fact, it's extra safe. It's the tornado shelter. There's a bathroom back there. You are free to use electronic devices and do whatever you want to do as long as you're not researching this case. You remain in that information bubble because you could be pressed into duty as a deliberating juror. You're free to talk with each other, but not about the case. Don't do your own mini deliberation and say, well, what would you have done in this case? Because we don't know if either or both of you might need to join that group. When they stop for today, we'll bring you out here and I'll give instructions to everyone, and then we'll have that conversation about, hey, I could be here in 20, 30 minutes, Judge. If you call me tomorrow at noon, because they're still deliberating, you had to excuse someone. But if your answer is, it's going to take me an hour to get here, then we'll just need you to show up when the jurors show up tomorrow. If they don't finish today, they may resolve things today. Questions about being an alternate?
So I just want to clarify, you're not deliberating, correct?
You are not, correct. So if you have anything back there, you can go get it. And if you have anything back there, sir, you should get it. Then you two will be in that room, not deliberating. You can talk, that's great, just like you could talk before right now. You can also use your devices, you can sleep, work, do whatever you want, but don't do any research about the case. You are still under that same set of restrictions because it could be that you do start deliberating if we lose, not as in we can't find them anymore, if we have to excuse one of those jurors. Did that answer your question? Questions? You got it?
Yeah.
Okay. Then if you guys would grab your stuff from the jury room, and then Deputy Gordon, you travel light, you got everything. Okay, do you have anything back there, ma'am? Great, if you'd grab that. Okay. So they want to start? I understand, but do they want to start now? Okay. Ms. Nix, how did you do with fitting stuff on the thumb drive?
It says that, I believe that it will fit everything. I'm at 40% right now.
Okay,
And yesterday when I was trying to put things on thumb drives, it would telling me automatically if there wasn't enough room.
Okay.
So I assume there's enough room.
great.
Now I'm at 41%. So it's.
It's doing its thing. Do you have another question?
Yes, you said that if we are like too far, you'll pick someone else.
No. What I said was, it sounds like we probably will not finish today based on when they need to leave today. And so we will need to have the conversation. We can have it right now. I will need alternates on warm standby tomorrow in case a juror has to be excused or one of them doesn't show up tomorrow. Then we're down one. And so one of you would join that group. So what I need to know is how quickly could you get here? If you've got your phone on you and you promise to answer it, not quickly. Okay. Then you're going to need to show up when they show up tomorrow. And you should bring extra things to do because as long as they're deliberating, you'll be in there. You can do work, you can do art. You just can't research about the case. Okay. How about you, sir?
Yeah, for me to take 2 hours to reach.
2 hours to get here.
Yeah, I come, I drive to Marta and then.
Okay, so you're a MARTA taker. So you'll both need to come tomorrow. When they're done today, and it sounds like that'll be around 5 o'clock, we'll get all 14 of you back in here and we'll talk about when people want to come back tomorrow. And if they vote 8 a.m., it's 8 a.m. If they say 10 a.m., it's 10 a.m. when they come back. And I'll just need you all to be here, just like you have been before, when everyone else gets here. Okay? Thank you. If you go with Deputy Gordon. Really? Oof. Yeah. You didn't leave like notes on the wall in there as you were preparing your closing.
As sure as I ever am that I left nothing in there, but I think it's probably prudent for the deputy to check, just in chairs.
Look for a big poster saying Tezera's innocent.
Or something else.
Ms. Nix or Mr. Peoples, anything else we need to cover before we can get the evidence out to the jury?
No, Judge, just if they're ready to deliberate, I mean,
If it's gonna take 20, 25 more minutes, I mean, we could just give them what we have
We should. I'm not worried about the video part. I didn't ask the question. Well, sometimes there is a disagreement between the sides about what goes back with the jury. Did you have any disagreement with Mr. Hirsch about what should go back with the jury?
No, Judge.
Okay, I know he was envious that the drugs were going back, but that's personal preference. Okay, you don't have any issue with the drugs going back there just for deliberations. They don't take them home. Okay, all right. Mr. Hirsch, anything you want to get on the record before we send things back to the jury and then we're at ease in here? We'll wait till the door closes. Yeah, it's all right. Will you grab your speaker?
To the extent I haven't or need to put on the record, I'm going to object to the videos going back with the jury because I think it's continuing witness. The witnesses are testifying. I think if they want to view it, they should ask a question, and then the court can exercise its discretion as to what and how to let them watch.
Okay. Pursuant to that, your objection is noted, and I'm overruling it. I don't believe, but I need to be corrected on this. I don't believe that any of the videos is a video of a custodial interview or anything like that. It's all body cam plus ring camera. Is that, I understand there are conversations had on these body cams, but it is effectively surveillance footage, everything. Am I forgetting any of the videos? This is not a case where Mr. Tezera was sat down in an interview room and he gives a statement for 45 minutes.
While he's in the hospital, he is read Miranda and interviewed. We didn't, because it was pretty much only about the fight, and then the officer not knowing enough to really do a sufficient interview, we didn't bring that up. I think that is one of the videos that is on the disc, but
Okay.
I cannot put it on this.
Okay. Mr. Hirsch, my thought would be that gets excluded because that is the type of statement that wouldn't go back if the video was merely a recording of an interview of someone, as opposed to these videos that are recording in the same way that a surveillance camera that was up in the hallway would have recorded what's going on. That's why I don't believe it's a continuing witness issue, but it is if they're taking someone's statement.
We can remove the video of Officer Skidmore or Investigator Skidmore at the hospital, and I think some of it got onto Investigator Philemon's body cam, but both of them kind of cut off there's a break, so
Okay.
So they're separate videos, so I can just
If you
them
exclude those. Okay.
Your Honor, the way I received them is they were separate body cam videos, so I object to any video going back that's not admitted into evidence. So in other words, I received a video from body cam from Officer Skidmore at the scene and a separate one when he was at the hospital. Same thing for, I think that's right. But of course, yes, Officer Skidmore, the state had said there's no statement, there hasn't been a Miranda hearing, so that shouldn't be on a video that's going back.
I agree. I think it's in evidence because Detective Skidmore said, I've looked at all the videos on this disc and this is my initial, and you didn't object to that coming in. And so if it had both pieces of the video, it's in evidence. Does it go back with the jury? I don't think it does. Not because it's not in evidence, but because that part would be, that's the continuing witness. It's an interview. It's like sending a deposition back. You wouldn't do that.
And also, I never waived any Jackson Deno issue on that.
That as well.
All right. I guess what I'm saying is, when I didn't object to the video, obviously I didn't go and watch the whole thing, but the body cam videos I got were only at the scene. So I think we've discussed the one about Officer Skidmore. However, Officer Foster also goes to the hospital and he also talks with my client. I also received that as a separate video than what Officer Foster, than his body cam video at the apartment.
We can just not include any videos from the hospital.
Let's do it that way. If that's an easy line to draw, it's not slicing or dicing existing nonstop videos, then let's not include on the thumb drive that goes out with the jurors, any hospital video. Because that's when there would have been those interactions for which we have not had a Jackson Deno hearing. And we haven't heard any testimony. We heard a very little bit of testimony about it, certainly not from Foster. I didn't know he'd gone to the hospital.
He went to the hospital, he got a statement from my client, and it was not Mirandized.
Okay.
I mean, it was
They
more of
were
a casual conversation, but
Yeah, they were just chatting. But I will remove anything from the hospital, and those are our two, only Philemon, Skidmore, and Foster went to the hospital, and they all have a break in their body
Great.
cams that I will take off,
Thank you.
not included in this video.
All right. Can Deputy Gordon take the non-video evidence back to the jurors? I'm asking you, Mr. Hirsch.
non-video evidence.
Well, in other words, the thumb drive's not done, and so that can't go back yet. I don't want to have them. I think everything should go back with the jury now, and the thing that they could play, they don't have yet.
The crime lab report, also I'm objecting to, and I don't think it goes back, because we didn't specifically discuss it, but so that should not go back.
We-
Okay.
Crime lab report.
We did specifically discuss it when we asked about if we could put it in the,
If it was admitted and published.
if we could put it in the PowerPoint.
Right, and you did, and he did not object to that. That doesn't make it go back. It's like the coroner's report. I don't think it goes back. So I hadn't heard Mr. Hirsch object to anything, so I assumed he didn't care that it went back, but.
My understanding, Your Honor, is that it would, I mean, it doesn't possess any, any narrative or anything like that. It's a scientific finding. And there's not any narrative to, how it gets there or anything like that, or who. It explains what it is, how much it is, and what it weighs.
Okay. And your basis for keeping the crime lab report out?
Continuing witness. Right?
Okay, all right. If they want to see it, we can publish it for them when they're out here. Are you able to find it? You got it?
Yeah, so,
Great.
Your Honor, what's going back right now are all photos and State's Exhibit 18 and 19. Those two crime lab reports I'm handing to Your Honor. I think everything else. I think everything else is a photograph. This video here, these videos are not sending back.
We are sending the disc back, just so they know that they just can't play them. The media that this machine that they can't see anyway right now is, it accepts thumb drives. I mean, it's a USB connection.
And then, State's Exhibit number 26, looks like the small bag, 29 is the scale. I have no objection to that. State Exhibits number 1 is the business records certificate. I think that's continuing with the subject now.
All right.
That's fine. Take one. And then 20, 21, and 22.
Right, and then I think all the defense exhibits that were admitted go back. The transcript was not admitted. It wouldn't go back if it was. But everything else is photos. And are they all in there, the defense exhibits?
Yes.
Okay, great. Thank you, sir. Have you already collected their devices? You swap them?
Yes.
Okay,
And Judge, myself and defense counsel have also looked at the box of gloves that are not here.
good.
We provided them to Deputy Gordon.
Thank you. Can you please, Mr. Peoples, grab one of those note cards and on it write one phone number for the prosecution and then get a number from Mr. Hirsch so that if you guys stray from this room and I need you back, we just have to dial 2 numbers. Thank you.
This is Max Hirsch's.
Okay. Sorry. I thought you were gonna give them this card.
Thank you. Okay, I will mute the microphone in just a moment. You all can be at ease. I think I said this loud enough for everyone to hear it, but according to Deputy Gordon, the group needs to or wants to stop at 5, so they're only going to deliberate for about 30 minutes. So don't go too far away, because at a minimum, we'll be reconvening in about a half hour. Where are we percentage-wise on your slow-moving thumb drive?
62%.
All right. Well, they'll have it tomorrow morning. All right. Are we on the record? Question 1. Hold on. Question 1 did not involve 55700. Does or did the defense have an ability to subpoena or solicit the ring video on their own? Question 2, in this different handwriting, in this case, did the defense have the legal right or opportunity to subpoena the ring camera footage from McCall's apartment? Do you need me to reread them, Ms. Nix?
No, sir. It seems to be the same question.
It is. I mean, it's separate, but they're getting at the same thing. Mr. Hurst, do you need me to read those again?
No.
I propose writing, yes, they did on the back of both cards and signing and dating it. Any objection to that, Ms. Nix?
What I was going to suggest.
Mr. Hirsch?
Yes, Your Honor, I object. I think the evidence is in. It's not about the evidence in this case. I would say you have the evidence. My request is that you say you have all the evidence in front of you.
Okay. I hear your answer. I'm going to give the answer that is in fact responsive to their question. All right, if you'd let them know I wrote on the back and we're not just handing them their cards back. Thank you. Ms. Rivers, are you ready? All right, we're back on the record in State versus Tezera. We have a third question from the jury. It says, does joint possession equate to reasonable doubt? Does joint possession equate to reasonable doubt?
I think you should say yes, Judge.
I like the short and sweet answers. That's not what I had in mind.
I think the jury, looking to their jury charges, I mean.
Why not? Not if you find that the defendant is one of the joint possessors.
Yes.
I guess I should say, not if you find beyond a reasonable doubt that the defendant is one of the joint possessors. I don't want to lessen their burden, but I think that's the most direct answer to what seems to be befuddling them. And because another answer is no, joint possession doesn't mean reasonable doubt, but it depends who the joint possessors are. If the joint possessors were Ms. McCall and Ms. Young, the woman in the white t-shirt, yeah, that's reasonable doubt. But if one of the joint possessors in their mind is Mr. Tezera, then consistent with the law and the instructions they've been giving, then the answer is no. That's why I think a more complete answer is not if you find beyond a reasonable doubt that the defendant is one of the joint possessors. Do you have an issue with that?
The state does not have an issue with that response.
Mr. Hirsch?
I would just ask you to say that you have the law in front of you.
Okay.
So yes, I do.
Okay. I have written, not if you find beyond a reasonable doubt that the defendant was one of the joint possessors. And I initialed it and dated it. That is over objection from the defense. The state does not challenge that answer. Please don't go anywhere, because I think the jurors are done for the day after they get this answer. That's what they were telling Deputy Gordon. So let's sit tight and see what they do next. what they're doing. It sounds like they're ready to go. We're waiting on them. So if they're ready, we also need to bring the two alternates in. However you want to engineer all this. We'll sit tight. Thanks. Any chair. Your favorite, well, actually, if you guys don't mind going all the way in, because we need to get all the other jurors to come in as well. Thanks. After all that, they're gonna make their colleagues sit right here? Okay. Excuse me.
If you don't mind signing that program, but.
All right, adjourned. All those present accounted for.
Thank you, Deputy Gordon. Everyone should be seated. So, my friends, Deputy Gordon tells me that you want to wrap for the day. Is that correct? Yes, lots of yeses. As I mentioned earlier, you're the boss now with scheduling, and actually we could hear you, 9:30. When would you like to report tomorrow? It actually affects your colleagues who are the alternates because they need to be here as well. So we need to know when to have the welcome mat out.
9 a.m.
9, okay. I'm glad that there weren't two different answers. Great, you know how to do that. 9 a.m., the shuttles run like they always do if you're a shuttle person. It is as important as ever that you not talk about this case with others tonight. Go home and say, yep, another great day. Let's watch Netflix and binge on something. Preferably not like a court show. Don't watch The Lincoln Lawyer or something. No outside research. You can think about it. And when you come back, talk with your colleagues about what you've been thinking. That's okay. It's just don't interact with people about it. When you are back tomorrow, all that evidence will still be there. It'll be left exactly as you left it. And I'll ask our two alternates to also be here by 9, and you'll get to be in the special bonus room while your colleagues continue to deliberate. Do you all have any logistical questions? You've asked a few questions. I provided written answers. Did you receive the cards back? I write on the backside. Okay, good. Then have a good evening. Appreciate your focus and dedication. I'm having court all day tomorrow. We will stop whatever is going on anytime you all need to come out here. So if there's some question that I can't answer, in writing, but I am allowed to answer, but maybe I need to talk with you all, we'll just bring you out here. Don't be confused or thrown if it's a different composition of folks. Based on the lawyer's estimate, I booked lots of tomorrow because we have other cases. And so there'll be people in here, they'll get moved to the side whenever we need to return to State versus Tezera. So you won't get stuck waiting, okay? Thank you. See you at 9. Oh, one last thing, you need to police each other. You cannot start deliberating until all 12 of you are back. So if one of you has been kind of slow, pick them up on the way here, do what you need to do, because we can't start till all 12 of you are here. Thank you. Yeah. All right, Ms. Nix, anything from the state? What are we at?
I was just showing Mr. Hirsch that the only videos are the ones that were shown already to the jury. And so there's just one more that I was gonna let him look at.
Okay.
And then I think we'll be able to, so this is scheduled. So he turns it on. This works a little bit of phones without being more right.
Your Honor, I've been shown it. I obviously maintain my objection about it going back and making sure only what's been admitted goes back with the jury.
Okay, well, the former was an objection, the latter was a note of concern that I agreed with, and it's been represented to me by Ms. Nix that those things have been removed. Do you have any reason to think they were not removed?
No.
Okay, so that thumb drive, which is labeled.
It's labeled State's Exhibit 28, and it has Officer Suk's initials on it, as this was originally only containing his video.
Got it. Let's try to remember when the trial is over, whatever the outcome, to remove from Exhibit 28 everything but Officer Suk's video.
Yes.
But it's a great place, it's a great receptacle for everything else. And I'll explain to the jurors tomorrow before they get started, or it can be after they get started. Deputy Gordon can explain what 28 is. I'll have him give that to them tomorrow morning.
Yes, sir. And I don't think that we specifically discussed this, but I did show Mr. Hirsch that I have the 911 calls on there.
Okay.
Because those are also only available on this.
And they should be made available in the way we have. Thank you so much. Anything, Mr. Hirsch, from your side?
No, Judge.
All right, when you get here tomorrow, if you don't mind not setting up shop there, you're welcome to leave some things there, but what do we have tomorrow? It's a little inquiry calendar and something in the afternoon. So there'll be a few other attorneys. They'll just need some of that real estate. And then we'll get them out of the way anytime something comes up in Mr. Tezera's case. Okay?
Yes, sir.
Thank you, everyone.
Don't we only have afternoon?
Can do it during lunch.